Hello, good morning, and welcome to Byju's Exam Prep. We are continuing with our discussion on judiciary. Till now, what all have we discussed? The role of the Supreme Court, in a sense, what are the powers of the Supreme Court? What is the original exclusive jurisdiction? What is the writ jurisdiction, which we have covered in Fundamental Rights chapter? Then what is advisory jurisdiction? What is appellate jurisdiction? What is revisory jurisdiction? We also looked at how the judges of the Supreme Court and High Court can be removed from their offices. And it is such a complicated process that till date, no judge of the Supreme Court or High Courts have been removed. Then we also looked at that the seat of the Supreme Court shall be in Delhi, but the Supreme Court can sit in Delhi or in any other place or places as the Chief Justice of India, with the prior approval of the President, will appoint. And there we discussed a reform that either constitutional bench of the Supreme Court should sit in Delhi and cassation courts should sit in different regions of India, or we should set up regional benches of the Supreme Court. Then we discussed what is judicial review, what is judicial activism, what is judicial restraint, and we looked at this new concept which emerged in 1979 onwards, known as public interest litigation. But what is judicial restraint? In simple terms, hesitancy of the judiciary to strike down the laws passed by the parliament, deferring to the public opinion. Since the members of the parliament are elected by the people, they are accountable to the people. So a law passed by the parliament, we will assume that it is constitutional. But over a period of time, judiciary started becoming an activist. What is the role of an activist? Activists, they protest, they organize rallies, they organize protests, programs to force the legislature to pass a law, to force the executive to have a particular scheme. For example, activist Anna Hazare forced the parliament to enact a Lokpal. Similarly, activists forcing the government to have Right to Information Act. This movement of right to information started in Rajasthan. But now if the judiciary starts becoming an activist and forcing the executive to do something or the legislature to do something, that means legislature and the role of the executive is now slowly and steadily taken over by the judiciary. And this is where we looked at the concept known as judicial legislation. What is judicial legislation? Legislation by the orders of the judiciary. For example, Vishaka guidelines. For example, controlling the money power and the muscle power in student elections. In another instance, anti-ragging norms. Were issued by the judiciary. We still see the menace of ragging, where new students, fresh students, they're being ragged by the seniors, and ultimately we saw a medical student recently committing suicides. We have strong anti-ragging procedures, norms in India, started by the judiciary, and that is also known as judicial legislation. But over a period of time, we have seen some of the disturbing trends in judicial activism, where the judiciary is getting involved into the day-to-day activities of the government, prescribing parking fee, issuing norms to control the monkey menace, asking the government you have to interlink the rivers, getting involved in the distribution of subsidies through PDS, getting involved in an ongoing military operation, for example, something that we saw in Hazratbal. So this is all pointing out to a direction where the judiciary is crossing a line, separation of powers, and getting involved in the domain of the executive, in the domain of the legislature. If this judicial activism is not checked, then it would lead to the violation of separation of powers, and that is what we call judicial adventurism or judicial overreach. How? Let's take a look. Look at this paragraph clearly. Over the years, the social action dimension of PIL has been diluted and eclipsed by another type of public cause litigation in the courts. So, what was the idea of PIL? Where publicly spirited individual or an organization will approach the Supreme Court on behalf of the weaker, marginalized sections of the society. In United States also, we have a similar provision known as social action litigation. And what is the social action litigation? In the sense that even in United States, somebody can approach the court for the larger society to take action for the larger society and their benefits. So, but over a period of time, the social dimension of this public interest litigation has been eclipsed by another type known as public cause litigation. And what happens in this type? The court's intervention is not sought for the enforcement of fundamental rights, is not sought for providing protection to the weaker, marginalized sections of the society, but simply in correcting the actions of the executive, in correcting the omissions of the executive or other departments of the government. In a sense, Lokayukta is not appointed by the state in UP. Supreme Court comes into the picture and appoints a Lokayukta. There are no guidelines for controlling monkey menace. This is an administrative matter where the executive has failed in discharging its duty, whether the executive is not doing enough to solve monkey menace or the lack of parking facilities in Delhi and other places. Similarly, we have seen an instance where the judiciary gets involved in policy making, saying you should not have used first come first serve basis as the basis for issuing spectrum to various companies. Instead, you should have opted for an auction route where more and more revenue should have been given to the state, should have been accrued by the state. So initially we thought that public interest litigation would help the weaker, marginalized sections of the society in getting access to justice, because judicial literacy is low. They are not aware of their rights. Or even if they are aware of their rights, the justice is costly because they have to get a lawyer, which they may not afford. So that was the idea. Let publicly spirited individuals, those who think about the larger public society, they can come and approach us. So primarily it was meant to give fundamental rights back to the people, back to the poor and the marginalized sections of the society. Now we are seeing a different type of public interest litigation, which is known as public cause litigation, where fundamental rights are not involved. But what is involved? Executive is not doing something, you're asking the state to interfere. When legislature is not passing a law, you're asking the judiciary to intervene and force the executive and the legislature in doing their job. And this has led to some of the disturbing trends in judicial activism. The Supreme Court ordered control over automobile emissions, air and noise and traffic pollution, gave orders for parking charges. You should start wearing helmets in cities, cleanliness in housing colonies, disposal of garbage, control of traffic in Delhi, wearing of seat belts should be mandatory, action plans to control and prevent monkey menace in cities and towns. All these are aspects which are primarily within the domain of the executive, where mostly we can say fundamental rights of the people are not involved. So judiciary is now encroaching into the domain of the executive and getting involved in the day-to-day activities of the government. This is disturbing because that is not the job of the judiciary. Similarly, in recent orders, Supreme Court, and we have discussed these examples, I'm just putting down on this slide. The Supreme Court has directed the most complex engineering of interlinking of rivers in India. The court has passed orders banning the pasting of black film on automobile windows. On its own, the court has taken notice of Baba Ramdev. Baba Ramdev started protests in Delhi at Ramlila Maidan, and one night the police entered Ramlila Maidan and forcefully evicted all those protesters. and court on its own said, you are violating the right to protest, we will interfere in this matter, without somebody approaching the court. In all these cases, you can say all these are managerial exercises by the court, and they are on the dubious jurisdictional peg that we are following Article 32 of the Constitution, wherein in reality fundamental rights are not involved. So that is disturbing. So the court is getting mostly involved in better administration, in effective administration. But that unfortunately is not the power of the court. The court should stay away from this. Otherwise, you're violating the separation of powers, which you have said is part of the basic structure of the Constitution. Something was said by Justice Jackson. Justice Jackson said, the doctrine of judicial activism. And what is this doctrine of judicial activism? Which justifies easy and constant readiness of the court to set aside decisions of other branches of the government. Justice Jackson says it is wholly incompatible with the faith in democracy, so far as it encourages a belief that judges should be left to correct the result of public indifference. And it is a vicious teaching. What does that mean? Judiciary getting involved in policy matters, saying 122 2G licenses should be cancelled, you should take auction route, you should not follow first come first serve basis. Judiciary getting involved in the distribution of subsidies through public distribution system. The idea of the court is that we will interfere. Why we will interfere? Because Article 32 is important. Why we will interfere? Because fundamental rights are important and we are the protector, we are the guardian of the Constitution. But this readiness that you want to interfere in the domain of the executive, in the domain of the legislature, this is violating the faith that people will have in democracy. Whether 122 2G licenses were given properly or improperly, that is for the people to decide. Whether PDS is rightly distributed or not, that's for the people to decide. Because after all, in a democracy, these elected representatives are accountable to the public, are responsible to the public, or they are responsible to the lower house of the Indian Parliament, which is the Lok Sabha. So judiciary should stay away from this and not get involved in the matters of politics, because then you are weakening democracy. Because then you will not approach, I as a citizen will not approach a minister, will not put pressures on the ministers or the elected representatives. I will directly go to the court. But these are unelected people. And we have seen classic examples of judicial overreach. For example, judicial appointments. Collegium system is not mentioned anywhere in the Constitution. Whether it is Hazratbal operation, whether 122 2G licenses, whether Andhra Pradesh High Court's order on Article 356, all these point to a direction that judiciary is now even more ready to interfere in the domain of the executive and the legislature, which Justice Jackson says is incompatible with the idea that people have faith in democracy. But over a period of time, we have now seen another trend emerging, and that is known as judicial evasion. And what is this judicial evasion? Let's try and recap. Public interest litigation, where any individual, any public spirited individual for the larger public interest will approach the court on behalf of weaker, marginalized sections of the society. Since their fundamental rights have been violated, they cannot approach the court. We are approaching you on their behalf. And the court has lowered the idea of locus standi. While you are filing a public interest litigation, the court will not ask, who are you? What is your relation in this case? How are you connected with this case? Are your fundamental rights being violated? Are you an aggrieved individual? The courts will not ask, but will provide justice to the people. And through this public interest litigation, we have seen lots and lots of improvements have been made. For example, the scope of Article 19 has been expanded because of PIL. The scope of Article 21 has been expanded because of PIL. Lots and lots of environmental protections have been provided to the people. Clean air, safe drinking water, pollution-free environment, noise pollution. All these are areas which affect your dignity. So we will ask the state that you should ban firecrackers during Diwali because it affects the right to life and right to clean environment of the citizens, particularly the children. But should firecrackers be banned or should they be regulated? Three kids approached the Supreme Court through their parents that when firecrackers are being used in Delhi and in other parts of the cities during Diwali, we see the pollution spikes in these areas. It affects our lungs, it affects our health. Since under Article 21, right to health is my fundamental right, right to clean environment is my fundamental right. My fundamental rights are getting violated during Diwali. But should the court look at only from this angle that kids, children, and elderly people, their right to health, their right to clean environment has been violated? Or should the court also look at those manufacturers of the firecrackers? Because it is also their fundamental right to take up any trade, any occupation, any profession. How does the court balance the two rights? Right of children in getting access to quality air and the right of those businessmen who have the fundamental right to take up any occupation, any trade, any profession. This is where the court has to have a delicate balance. Otherwise, you are violating the fundamental rights of one section of the society in the interest of protecting the fundamental rights of other sections of the society. Initially, the point was that judiciary was exercising restraint. Judiciary was not too eager. Judiciary was not ever ready to strike down the laws passed by the parliament or strike down the actions of the executive. That is how we saw first Constitutional Amendment Act challenged in the court. It was not struck down. Ninth schedule was added. It was not struck down. Article 15 was amended. It was not struck down. So various changes were made to the constitution. They were not struck down initially. But over a period of time, this judicial restraint then turned into judicial activism, where now the Supreme Court is ready, is quick in striking down laws passed by the legislature, laws passed by the executive, or the actions of the executive. That is what we call judicial activism. The readiness, the eagerness of the court to strike down the actions of the executive and the legislature. And we saw the classic examples of Keshavananda Bharati judgment. We saw the classic example of the Maneka Gandhi judgment, where in the 1978 Supreme Court said, forget about procedure established by law. We are following due process of law. The innovation of the doctrine of basic structure, which gives unlimited power to the judiciary, that you decide what is part of the basic structure. So judiciary gets to decide what are these areas of the constitution which are so fundamental that even parliament cannot change. And it reached to an extreme in 2015, where Supreme Court said primacy of Chief Justice of India in judicial appointments is also part of the basic structure of the constitution. But over a period of time, when judiciary started becoming hyperactive, becoming an activist over a period of time, then we saw another trend emerging, judicial evasion. What is this judicial evasion? There is a matter X before the court, before the Supreme Court. Previously, judiciary would exercise restraint and say, no, this law is constitutional, or this case is dismissed, because you are siding with the executive, you're siding with the legislature. You say that since there is presumption of constitutionality, the law should be constitutional. Then came the readiness that this law is unconstitutional. Even if it violates one aspect of the constitution, it's unconstitutional. But now we are seeing a trend where the court is not giving an order at all. Court is keeping the matter pending for a long time, and thereby siding or favoring the executive. Executive in the sense, demonetization. In 2016, demonetization was carried out, where in one One fine evening at 8 o'clock, Honorable Prime Minister addresses the nation and says, Mitro, beginning midnight, 500 and 1000 denomination notes will cease to be a legal tender. If you look at this note, it is mentioned that RBI governor says, I promise to pay the bearer the sum of 1000 rupees. I promise to pay the bearer the sum of 500 rupees. So this is your property. Right to property is a constitutional right under Article 300 capital A. Can this property be snatched by a notification issued by the executive? Or can this property be snatched by passing a law? Because in 1978 also demonetization was carried out, but that was carried out through ordinance. Ordinance is basically a temporary law. But in 2016, when demonetization was carried out, it was carried out by a government resolution. Cabinet issued an order and demonetization was carried out. Is this constitutional or not? Matter went to the court. 2017, 18, 19, 20, 21, 22, finally in 23, Supreme Court gives an order and says demonetization was legal. What is this? Judiciary is evading its responsibility, saying we will decide this matter, but not now. When the Supreme Court says not now, thereby you are favoring the executive. Favoring the executive how? Even if 2023 Supreme Court would have said demonetization is unconstitutional, you should not have done it like this. The proposal should have come from the Reserve Bank of India. But in this case, the proposal has come from the government of India. Then where is the autonomy of the Reserve Bank of India? Because Reserve Bank of India has the control over the money supply in the economy. And you should have passed a law instead of issuing a resolution. Even if it was said by the court in 2023, what impact would it have? Demonetization is over. It has been carried out in 2016. This is called judicial evasion, where sensitive topics, the Supreme Court is not deciding. When it is not deciding, it is basically saying, not now. We will hear this matter, not now, not now, not now. And thereby, you are favoring the executive. Electoral bonds, for example. What are these electoral bonds? Listen to me carefully. Do political parties need money? Yes. Why? To contest elections, they need money. To organize rallies, they need money. To communicate their ideology to the people of this country, they need money. So there is absolutely no two opinion on this that political parties need money. They need money, definitely. But this money should be clean money. There was a time when a political party was given donations. By whom? By corporates, by individuals like you and me. Initially, the system was all the donations about 20,000 rupees, you have to reveal the donor. All the donations less than 20,000 rupees, no need to reveal the donor. What does that mean? If I am the political party and people are donating money to me, corporates are donating money to me, should this be known to the public who is donating money to me? Yes. But if we are telling all the people of this country, even the names of those who donated 1 rupee or 10 rupee or 1000 rupee, it becomes very difficult for a political party to maintain this record. Because I organized a rally, and in this rally, I placed a box, donation box. I'm asking the people, whatever money you want to donate, please donate in this box. People come, donate 500 rupees, 1000 rupees, 2000 rupees. So how can I keep a track of all these donations? I cannot. That is why the law said, if somebody is donating you less than 20,000 rupees, you should not reveal the donor. But somebody paying you, donating you more than 20,000, you have to reveal the identity of the donor, because the people have the right to know. Because in Association of Democratic Reforms case, the Supreme Court said right to know is the fundamental right of the people when it comes to the candidate contesting the election. I want to know which corporate is donating money to you. For example, if I am a firm believer of environmentalism. I want our environment to be protected. And I think that the policies of this political party, they're great. They want to preserve the environment. They want to ensure that our ecology is not disturbed. I will vote for you. But if I also realize that there is a biggest pollutant, a corporate entity which is into mining, which is into pollution, which causes pollution, and that political party, that corporate entity is also donating to you, I will not vote for you. Because I know if you come to power, you will favor this corporate entity by passing favorable laws, by issuing orders which will favor this corporate entity. Otherwise, why would this corporate entity donate to you? If they have invested 1 crore rupees in you, their idea should be, I need to double, triple, or 10 times make the investment. I should get 100% in return. That is why political parties get donations from these corporates. But the point was, any donation above 20,000, you have to reveal the identity of the donor. But political parties, they are clever. Clever in the sense, I am Mr. Adani. I donated 100 crore rupees to the Congress, not the BJP. I donated 100 crores to the Congress. What the Congress party will do, it will break this 100 crore into receipts of 19,999. So I got 100 crore donation from Mr. Adani, but what I will do, I will ask my chartered accountant, break this 100 crore into receipts of 19,999 so that I don't have to reveal the identity of the donor. And this is where, when these political parties, they have to announce, they have to reveal what is the source of your donation, what is the source of your money, they have to reveal it. Congress party was asked, where do you get the donations? Congress party said 67% of the donations came from unknown sources. Unknown sources, that means 67% of the money that we got was donated by people in amounts less than 20,000. So we don't know what is the identity of these donors, and we can't reveal it as well, because the law says any donation less than 20,000, you don't need to reveal the identity of the donor. But 33% of the donation came from known sources, and these are those who have donated money to us. BJP was asked, what is your percentage? BJP said 83% of the donation came from unknown sources. Okay. Samajwadi Party, what is the amount of donation that you got from known and unknown sources? Samajwadi Party said 95% came from unknown sources. Benji, Mayawati, come here. What is the amount of donation that you received? Mayawati said 100% donation, my lord, came from unknown sources. I don't know who donated money to us. They know who donated money to them. But what they do, they break this donation into receipts of 19,999 so that they don't have to reveal the identity of the donor. Mr. Jaitley was the finance minister in 2017. Mr. Jaitley said, we want to clean our electoral system. How? Cash can be viewed as illicit money. Cash in the sense, I am a big developer. I have 100 units of flats, which I'm selling the people. But if the value is 1 crore, I take 40 lakh rupees in the form of check and 60 lakh rupees in the form of cash. Political parties know that. Governments know that. Governments also know what is the amount of money that you have stashed using this route. And then the political party in power will ask for a share. And then some amount of this cash will be donated to the political party. So cash can be viewed as some form of black money, unaccounted money. Mr. Jaitley said, now we have to limit these cash donations. And for that, we are implementing the biggest reform, electoral reform in the history of independent India. What Mr. Jaitley said, we will start with electoral bonds. What are these electoral bonds? If you are a donor and you want to donate money to a political party, what you should do, you should approach the State Bank of India and buy an electoral bond. But this electoral bond, you can buy only through check or through digital transaction. Through cash, you cannot buy this bond. Why? Because the cash is black money. The black money that you have by selling these flats, you can use this cash to buy these electoral bonds and then donate money to political party. We will not accept these donations. If you want to donate to a political party, buy an electoral bond, but through check, through digital transaction, RTGS, IMPS, Paytm Karo, whatever it is. But buy these electoral bonds, not through cash. And then this electoral bond will be deposited into the bank account of a political party, which will be kept under the supervision of the Reserve Bank of India. So I want to donate money to the BJP. I approach the State Bank of India, give me an electoral bond. 1,000 rupees, 10,000 rupees, 1 lakh rupees, 10 lakh rupees, 1 crore rupees. I can buy as many electoral bonds as possible. I bought these electoral bonds and then deposit into the bank account of a political party, which is the BJP, for example. Now, BJP has 15 days to encash this money. 15 days are given to the BJP since electoral bond has been submitted, deposited into your political party's bank account. You have 15 days to encash this money. And now I have encashed this money, and this money, which is clean money, definitely clean. Why? Because it is through check or digital transaction. It is accounted money. Then this money I can use for the campaigning of elections. So this was considered, this was built as one of the best electoral reform, but only on the surface. As you dig deeper, it has major flaws. Flaws in the sense, this entire process is anonymous. Who is this donor who is buying this electoral bond from State Bank of India and donating money to a political party? Nobody gets to know. Nobody gets to know. Not even the Election Commission of India, not even the Supreme Court, not even the Reserve Bank of India. Nobody gets to know. And forget about them. People don't get to know at all. So shouldn't I, as the citizen of this country, get to know and have the right to know who is donating money to which political party, so that I can tomorrow keep a check on this political party? If Mr. Adani has donated money to Congress, tomorrow Congress comes to the party, comes to the power, and Congress will make laws, implement policies which will favor the business interests of the Adani group, which basically means there is a quid pro quo. You are donating money to political party with the hope that when this political party will come to power, it will make rules, it will make norms which will help my business. I can then put pressure on the government and say, no, why are you favoring this political house? Why are you favoring this corporate house? You should not do that. You have taken money, you have taken donation. But now because of electoral bonds, I never get to know. So it violates transparency. It violates the citizens' right to know who is donating money to which political party. And not just that, it violates free and fair elections. How free and fair elections? Elections should be free and fair. What is free election? Free election in the sense, anybody can contest elections. It should be free for all. Anybody can vote in the elections who has completed the age of 18. And now elections should not only be free, it should be fair as well. Fair in the sense, I'm allowing every single citizen above the age of 25 to participate in the election, to contest elections. But when the votes are to be counted, I will not count the votes of those where you are favoring the opposition candidate. I will ask the Election Commission to only count those votes which are in favor of me. That means election was free, but it was not fair. Because when we started counting the votes, I discarded the votes given to the opposition. I am asking the Election Commission to only count those votes which are in my favor. Elections were free, but they were not fair. We need both free and fair elections. And elections today need money, because you have to give biryani to the voters, liquor to the voters, Unfortunately, now drugs are given to the voters to coerce them, to bribe them to vote for you. So money is required. But if there is one political party which gets all the donations and other political parties do not get the money, so now this asymmetry will be created where this political party will always win the election because they have the money, they have more money. And who is this political entity? The government of the day. Why? Today it's the BJP, tomorrow it can be Congress, then it can be Aam Aadmi Party, then it can be my party, then it can be your party, can be any party. But the ruling party at the center knows everything about electoral bonds. If there is one entity which knows everything, that's the government of the day. How? I want to donate money to Congress, which is the opposition. I approached the State Bank of India. I bought these electoral bonds. State Bank of India is a government bank. It's a public sector bank. The State Bank of India will tell the government, Mr. Amit Shah, sir, 20 crore worth of electoral bonds I have sold today. And Mr. X bought these bonds. Very good. Now we will see where will he deposit this money. And then this individual donates money into the bank account of the Congress. This bank account is under the supervision of RBI. RBI governor, sir, 20 crore worth of electoral bonds deposited into the bank account of the Congress political party. Amit Shah says, drop the phone. Calls that corporate house or that donor. Why are you not donating money to us? Sir, I don't have any money. Otherwise, I would have donated money to you. Then why did you donate 20 crore rupees to Congress? Withdraw that money. Don't donate them. Donate this money to us. Sir, I can't do that. ED, CBI, National Investigation Agency, Enforcement Directorate, please come and investigate corruption allegations against this corporate house. So as a corporate house, I know that government knows everything. So I will hesitate in donating money to the opposition. Because if I donate money to the opposition, government comes to know, then government will investigate matters related to me, will start putting pressures on me, Enforcement Directorate, NIA, CBI. Ultimately, I am in the jail. That is how, when matter went to the court said, please reveal. Don't reveal who donated money to you, but reveal through electoral bonds what is the amount of money that you received. Don't tell us who donated money to you, but tell us through electoral bonds what is the amount of money that you raised. And more than 90% of the money through electoral bonds was raised by the ruling party at the center. It violates free and fair elections when the ruling party at the center will have all the funds and the opposition will have no money to contest elections. This violates free and fair elections, which is part of the basic structure. This violates right to know about the candidate. If I am the voter, I have the right to know about the candidate. This right to know is getting violated, which is also my fundamental right. Matter went to the court in 2017. My lord, electoral bonds are unconstitutional. We will hear it. 2018, the case was not heard. 2019, the case was not heard. 2020, the case was not heard. 2021, the case was heard. Sir, can you please stop the electoral bonds for some time? Till the time you decide whether it is constitutional or not? Because now elections are to be held in these states. And the government has again opened the window that you can donate money through electoral bonds. The court said, but this scheme is working since 2-3 years. If for 2-3 years there is no problem, what is the problem if we open the window one more time and allow entities to donate money to political parties through electoral bonds? My lord, but 2 to 3 years you did not hear this case. So we will hear this case. Don't worry, we will hear this case. 2021, 2022, 2023, 6 years, the case is not heard. What is this? Judicial evasion. And through this judicial evasion, what are you basically doing? You are siding with the executive. You are favoring the executive. So judicial restraint, not striking down the law, but saying it is constitutional. Judicial activism, eagerness to strike down the actions of the executive and the legislature when they are blatantly unconstitutional. But judicial evasion, not now. We will hear this matter, not now, not now, not now. Thereby you are siding with the government. Article 370 petitions. Article 370 was diluted on August 5. Matter went to the court, said the manner in which it was done, it is unconstitutional. We'll hear this matter. Okay. Jammu and Kashmir Reorganization Act was passed. Matter went to the court, said this Jammu and Kashmir Reorganization Act is unconstitutional. We will hear this matter. Delimitation was carried out. Matter went to the court that whether this delimitation should have been carried out or not. The court said delimitation is constitutional. But what was the last petition filed? Delimitation. Look at me carefully. Is delimitation constitutional? This was the last case filed in the court in 2022. The court heard this matter first and said delimitation is constitutional. Other petitions pending since 2019, the court is not hearing. So ideally, the first case that the court should have heard is whether Article 370's dilution was constitutional or unconstitutional. Because if that is unconstitutional, then Jammu and Kashmir Reorganization Act is also unconstitutional, then delimitation is also unconstitutional. But the court is not hearing this matter. Supreme Court was asked, said, please hear this matter urgently. Because on October 31, the state will be bifurcated into 2 union territories. The court said, don't worry, if there is anything unconstitutional, we will turn the clock back. Even if today the court is saying Article 370's dilution was unconstitutional, what is going to happen because of that? The state has been split already. 2 union territories have been created already. They are now working for the past 3 years already. Judicial evasion, not acting at all. Petitions challenging Citizenship Amendment Act pending for a long time since 2019, not decided by the court. There was a ban on internet in Jammu and Kashmir, and there the Supreme Court invented something else. What? The Supreme Court asked the Secretary of Information Technology, the Secretary of Ministry of Home Affairs, and the Chief Secretary of Jammu and Kashmir, you decide whether internet ban should be lifted or not. Matter went to the court that in Jammu and Kashmir, internet has been blocked. It affects right to livelihood. It affects the fundamental rights. Please say that internet ban is unconstitutional. Supreme Court said, let's take this matter to the 3-member committee. We will set up a 3-member committee. We will ask them whether internet ban should be removed or not. Who are these 3 individuals? Secretary of Information Technology, Secretary of Home Ministry, Chief Secretary of Jammu and Kashmir. You tell us whether internet ban should be removed or not. But the point is, who imposed this ban? These 3 individuals. The Union Home Secretary, the Secretary for Information Technology, the Chief Secretary of Jammu and Kashmir, they imposed this ban. And the court is asking now, you tell us whether this ban should be removed or not, whether this ban should be lifted or not. So this is another case of judicial evasion, where the Supreme Court, instead of saying not now, is saying not us. Previously, it was judicial evasion. Not now. We will hear this case, not now. You're evading a response, evading the judgment, not now, not now, not now. In Jammu and Kashmir internet ban, something else was invented. The Supreme Court appointed that committee, the members of which were responsible for the internet ban. So basically, Supreme Court is saying, on this matter, it is not us. It is them, they will decide whether internet ban should be lifted or not. And this is what is known as judicial evasion, where judiciary is evading the judgments on important matters, basically siding with the executive. That is judicial evasion. Any questions as of now? Why do political parties need to hide the source of money? Mr. Jaitley had a logic for that as well. He said a right to privacy is also a fundamental right. If I want to donate money to a political party, I don't want to be known as the donor of this political party because I have privacy. I don't want to reveal to anybody. And at the same time, if it is known that I am donating money to this political party, maybe if tomorrow some other political party comes to power, they will pressurize me, they will investigate me, they will put pressure on me. That is why the donor wants to remain anonymous. That is why we should not reveal the identity of the donor. Without buying electoral bonds, can we directly give donation to a political party? Yes, you can donate money to political party as well. Without electoral bonds, directly you can donate money to political party. Okay, we will stop Supreme Court right now here. We will revisit Supreme Court when we will discuss why are there cases, hundreds and thousands and millions of cases pending. But I've told you that Supreme Court, then followed by High Courts, then District Courts, then Gram Nyayalas. These are 4 institutions that we will have to discuss for the civil services examination. But we will focus more on the Supreme Court, but we should have an idea on these High Courts, District Courts, and the Gram Nyayalas as well. Let's have an idea about them. High Courts. Every state should have a High Court. But does that mean one High Court for one state? No. What is the difference? Every state should have a High Court. But there is a provision of joint High Courts for 2 or more states. That means, yes, every state should have a High Court, but that is not necessary that one High Court for one state. That means by that logic, we should have had 28 High Courts in India. That's not the case. How many High Courts do we have? We have 25 High Courts. Which means every state will come under a High Court, but one High Court per state, that is not necessary. Which means we can have joint High Courts as well. Punjab and Haryana High Court is for jointly for Punjab as well as Haryana. Similarly, Guwahati High Court is for Assam, Arunachal, and another state. We have joint High Courts as well. How many High Courts can we have? We have 25 right now. What is their composition? Determined by the President. There shall be a Supreme Court headed by the Chief Justice of India and not more than 7 judges. Can we increase the number of judges? Yes. Who can do that? Parliament, by passing a law. Clear? And right now we have Chief Justice and 33 other judges. Correct? Now we have High Courts. How many High Courts do we have? 25. What is the composition of an individual High Court? That is the determination of the President. That is determined by the President. Basically on the advice of the government, in consultation with the Chief Justice of that High Court, in consultation with the Chief Justice of India. So a particular High Court will have a Chief Justice and 3 judges, Chief Justice and 30 judges, Chief Justice and 20 judges. Who will decide that? Who will decide this composition? Determined by the President. But not on his own, after consulting the government and consulting the Chief Justice of India. Clear? So this is the composition. Now, what is the qualification to be appointed as the judge of the High Court? We know that. Clear? How are these judges appointed? We know that as well, through the collegium system. How are these judges removed? We know that as well, by the President, based on the resolution passed by both houses of the Parliament by special majority. We know that. This is what you need to know from High Courts. But there is one important topic relevant for High Courts, but for your mains examination, that we will discuss slightly later. So Supreme Court at the top, then High Court for every state. But that doesn't mean one High Court per state. We can have joint High Courts as well. What is going to be the composition of a High Court? That's determined by the President in consultation with the government and the Chief Justice of India. Clear? How are these judges appointed? How are these judges removed? What is the qualification? We have discussed in Supreme Court's chapter. Have we? Done. What is relevant for High Courts from the mains perspective? That we will discuss slightly later. But this is important for your prelims examination. Then just because below High Courts, we have District Courts. Which are these district courts? We also call them district and sessions court. And the judge who is presiding over this court is known as the district and sessions judge. Sir, what is the difference between a district judge and the sessions judge? This is a case before the district court. This case can be a criminal case. This case can be a civil case. Right or wrong? Right. When a district court is hearing a criminal case, we call it sessions court. When a district court is hearing a civil case, we call it a district court. And the judge who is hearing a criminal case, we call him sessions judge. And the judge who is hearing a civil case, we call him a district judge. That's the difference. So we have Supreme Court for the entire country. For every state, we have the High Court. For every district, there is a district court. And this district court is known as district and sessions court. When I'm hearing a civil case, I am a district court. When I'm hearing a criminal case, I am a sessions court. And this judge, when I'm hearing a civil case, I am a district judge. When I'm hearing a criminal case, I am a sessions judge. That is why, what is my designation? District and sessions judge. And what is this court? District and sessions court. But how am I appointed? In most states, there is a judicial examination. Judicial examination in the sense, just like we have State Public Service Commission to appoint state officers, state police officers. In a similar fashion, the State Public Service Commission organizes this judicial examination, and those who pass this examination, they are appointed as the district and sessions judge. And who appoints them? The governor of that state. But there is another way in which these district judges can be appointed. For example, the governor of that state will appoint a district judge who has been an advocate for a long time in the state on the recommendations of the state high court, on the recommendations of the chief justice of that high court. The governor appoints these judges to the district courts. That means at the district level, what do we have? We have the district courts. Who are the judges of these district courts? There are two ways in which these judges are appointed. One, through examination, appointed by the governor. All those will be appointed who have cleared the state judicial examination. Or those advocates who have been working in the state for a long time, 5 years, 10 years, 15 years, 20 years, and some of them can be appointed as the district judge by the governor on the recommendation of the state high court, on the chief justice of the state high court. That is about district courts. That is all that you need to know regarding district court. But just before district court, we have Gram Nyalas. Now listen to me carefully. I told you right at the start that Supreme Court, High Court, District Court, these are constitutional courts, that means created by the Constitution. Gram Nyalas are not mentioned in the Constitution. These are statutory courts. Statutory courts, that means created by the law passed by the Parliament. Gram Nyalas Act of 2009. What is the purpose? Simple. We have Supreme Court for the entire country. Yes, sir. We have High Court for every state. Yes, sir. We have District Court for every district. Yes, sir. But in a district, there are villages. Many villages as well. The idea was to set up courts at individual villages. Those courts are Gram Nyalas. So that we want to reach at the doorstep of every single place in this country. Justice should be accessible to all. Supreme Court at the top for the entire country, High Courts for all the states, district court for every district, but within the district, there are various villages. There are a number of villages. The idea was to set up Gram Nyalas at the village level so that we can reach an individual village and impart justice. But sir, wouldn't it be very costly? If for every single village, if for thousands of villages in India, we have one court each, that is going to be costly as well? Yes. Then what is the solution? The idea was that these Gram Nyalas would function as mobile courts. What is a mobile court? A vehicle will be provided. There will be a judge seated in this vehicle. There will be an official of the judiciary as well. Clear? And now this vehicle will move from one village to another village, then to another village, then to another village. So all the cases that are pending of the villagers in that particular village, they will approach this mobile court. They will approach this vehicle. The case will be heard. Then this vehicle will go to another village. Then this vehicle will go to another village. So the idea was that these Gram Nyalas should function as mobile courts. They will move from village to village and impart justice. So the idea is justice should be delivered right at the door of the people. But this is a big exercise. And this big exercise requires money. Lack of funds is what is making the existence of Gram Nyalas dicey. It requires a lot of funds. That is why the idea was more than 3,000 mobile courts should be created, but we have not been able to create more than 600 mobile courts. So we need more funding, more infrastructure, more money, so that the idea of mobile courts is well established, so that the justice is delivered right at the doorstep of the people. Which basically means we have Supreme Court for the entire country, High Court for every state, District Court for every district, and the idea of Gram Nyala, which originated in 2009. These are statutory courts. The idea was that we should give justice right at the doorstep of the people. So these Gram Nyalas will function as mobile courts, will travel from one village to another village to impart justice. But since it is a capital intensive thing, it requires more money. Lack of funds is what is not making these Gram Nyalas work properly. And we will discuss the implication of this slightly later when we will talk about the conclusion. What is the conclusion? According to 2021 report, there are more than 73,000 cases pending in the Supreme Court. Just Supreme Court. But if we add all the cases which are pending, not just in Supreme Court, but also in high courts and in the district courts, we have 44 million people, 44 million cases pending. And that is why we use the phrase, justice delayed is justice denied. 44 million cases are pending. Why is there such a huge backlog of cases in Indian judicial system? We can break down this problem into three areas. There are three reasons. Number one, holidays. Our judges take lots of holidays. This is, I think, my 22nd class. I haven't taken an off. 23rd class tomorrow. 24th class on Monday. No break, no holiday. But the judges, it is as if they are on holidays forever. How? Currently, Supreme Court has 193 working days. Out of 365 days, Supreme Court works for 193 days. High courts work for 210 days. District courts work for 245 days. Remaining, holiday. Supreme Court has 5 vacations in an annual calendar. And this issue was also flagged by the Union Minister of Law and Justice. Summer break of 45 days, winter break of 15 days, holy vacation of 1 week, then 5 days each for Dussehra and Diwali, and there are 73,000 cases pending before the court, and every year it increases by 19%. So problem number one, is the vacation. The court is not sitting for 365 days. The court is not sitting for majority of the days. 193 days for the Supreme Court, 210 for the High Court, 245 for the district courts. The cases keep on pending. Now, you might say they also need to freshen up. They also need a break. But these many breaks, 45 days summer vacation, this is basically a colonial thing. Colonial thing in the sense, when European judges, when British judges would come to India and will decide whether Indians are guilty or not, during the peak harsh summer season, they would go back to Britain. And this practice continued in India as well, even after independence, where during the summers for 45 days, the Supreme Court takes a break. That's not the only problem. The other problem is, it is the least digitized system in India. If you would have noticed, there are judges hearing this case, and then next to these judges, just below these judges, there are people on the typewriters, typing everything that is being discussed. Type it, type it, type it. The judges are very concerned about environment. But do they know what they do? According to Quint.com, the judges who appear deeply concerned about pollution and deforestation use at least 48 million sheets of paper, A4 sized paper. The text has to be typed. What is the font size? 13 to 14. Double spaced. That means if this is the A4 sheet, font will be 13 to 14. Spacing double spaced from this side as well as this side. Nothing will be mentioned. Nothing will be written. Only in this side, everything will be mentioned. And then the spacing as well. 3 centimeter from this side, 3 centimeter from this side. Keep it vacant. Keep it blank. But 13 to 14 should be the font size. 48 million sheets of paper they use every time. And it leads to delay. Why? I filed a case in the district court. I have to now approach the High Court if I'm not satisfied with this verdict. But the district court members are still typing the judgment. Still typing the judgment, typing the judgment. And then physically this copy is given to me. And then physically I have to approach the High Court. Why can't you put it on the cloud? Use information technology so that I don't need to waste paper, digitization, and at the same time, when the case is filed, even in the Supreme Court need not to have the physical copies of this judgment. It can look on the server, take a look at this judgment, and then decide whether this judgment was proper or not. That is another problem. Another problem is, bigger problem, that there are too many lacunas and gaps in Indian laws, which results in filing of several frivolous cases, thus increasing the number of litigations. Simple thing, anti-defection law has been passed. The law itself does not have clarity. What will happen when 2/3 of the members resign from a political party? Will anti-defection law apply or not? Are we talking about the merger of the legislative wing of the political party? Or are we taking into account the merger of the organizational wing of a political party? What is this merger? Merger of the legislative wing or merger of the organization wing? Deliberately, Parliament is not passing a foolproof law. It is creating loopholes in every law so that they can manipulate this law. Instead, make the law clear. Tell exactly what is the status of an individual MP who has been expelled by the political party. Say it clearly, whether it is 2/3 merger of legislative wing or 2/3 merger of organizational as well as legislative wing. When the law is not clear, then what do? We go to the court. My lord, I have been expelled by my political party. My lord, Uddhav Thackeray has been removed. I am Eknath Shinde. Now I am the real Shiv Sena. When the law is itself not clear, and this is not only about anti-defection law, every law has some loopholes, has some lacuna, and that is why the cases reach up in the court. That is a bigger problem. Even bigger problem is legal proceedings themselves are so complicated and ill-defined, and the rate of clearing the cases is abysmally slow. Adjournments. There is a case pending. I am one lawyer, opposite party has another lawyer. I say, sir, can we please adjourn this sitting today? Because I have to take my mom to the hospital. I don't have to take my mom to the hospital. I have another case in another court. The point is, Sunny Deol was right. Judge Saab, here we only get a date. We never get justice. Tariq pe tariq pe tariq, frequent adjournments. Frequent adjournments. And that too on inconsequential grounds. In a case of 50 hearings, on an average 10 to 15 adjournments take place. Sir, witness is not present. That is why, can you please adjourn this? Sir, I did not get the copy of this evidence. Can you please adjourn this? Sir, I have not read this document which has been presented by the opposite party. Can you please adjourn this meeting? Adjourn the case. We will read this matter and then come back to you. Sir, I need time to give you evidence. Please give me some more time. Lawyers themselves are not prepared enough, which leads to frequent adjournments, tariq pe tariq pe tariq, and ultimately the gap between the dates of hearing extends to several months. You're not prepared today. You don't have the copy of this evidence. Okay, now you want to adjourn this meeting. You want to adjourn this case. Okay, what is the next available date? Come back after 6 months. Why? Because during this period, I have to hear other cases. When adjournments are frequent, which means every case is to be heard for 10 times, 20 times, 30 times, 50 times also sometimes. Ultimately, it leads to delay, it leads to pendency of the cases, and cases keep on piling up, which have not been cleared by the courts. There was a report by Times of India, which said if all the judges of the Supreme Court, High Court, and District Court, they will work 365 days in a year. They will work 24 hours a day, without a lunch break, without a coffee break, without any break. It will still take 3 years for all these cases to be decided. 3 years. But imagine the number of cases which will be filed in this 3-year period. That is why we are in a big mess. And this mess is compounded by the fact that we have an acute shortage of judges. Ideally, we should have 50 judges per million population. But in India, we have only 10.5 judges per million population. So judges to population ratio is also poor, is also very bad. We should ideally have 50 judges per million population. We have 10.5 judges per million population. That is another problem. And then something else. Even if the number of judges are low, number of judges are less, even those which are sanctioned, we see vacancies. Sir, what does that mean? We have 10.5 judges per million population. But on paper, for example, the strength of a high court is 200. But if the strength is 200, the number of judges who are currently working are 100. Acute shortage. That means vacancies are not being filled. Look at this data. In all the high courts, 25 high courts that we have, and this is the strength, the most latest strength on 1st of November 2022. Total strength of permanent judges, additional judges, total is 1,108. What are the total vacancies? 335. Which means primarily on an average, 30% judges posts in different high courts are vacant. That is another problem. Economic survey. Last year's economic survey, it says that there are 3.5 crore cases pending. Since it is last year's economic survey, today it is 4.4 million. Much of the problem is concentrated in the district courts. High Court, Supreme Court, 73,000 cases. High Courts, lakhs of cases. But more number of cases are pending in the district courts. 87.5% of all the cases which are pending, they're pending in the district courts. So what we need to tackle is the pendency of the cases in the district courts. This is where more cases, 87.5% of the cases are pending. If these are the problems, Then what is the solution? What are the problems? Problems are there is pendency of the cases. In courts, you get date of next hearing, but you don't get justice. Tariq pe tariq pe tariq. What is the problem? Number one, the laws are poorly drafted. There is a lot of lacunae in the laws. That is why you reach the court. Clear? Second, vacation of the judges. They take lots and lots of holidays, lots and lots of offs. Third, judges to population ratio is less. Fourth, even the judges who are on paper, judges, these many judges should be appointed to high courts, district courts, but we see 30% of the vacancies. Adjournments on inconsequential grounds. Least digitized area in governance, judiciary. If these are the problems, then what is the solution? The solution is implement the global best practices. What are these global best practices? For example, in Scandinavian countries, Sweden, Iceland, Norway, what do they do? Before a person files an appeal in the court of law, you have to go for alternate dispute resolution mechanism. What is that alternate dispute resolution mechanism? You and me have a dispute on property, on land, on contract, anything. What do I tell you? What do you tell me? I will see you in court. I can't use any other language. I can't give you any other threat because I know only one thing. I will drag you to the court. I will see you in the court because we have no other alternative, or at least we don't know that there is an alternative, and there is an alternative. And that alternative, alternate dispute resolution mechanism, what we can do is, what are these alternatives? Good offices. What is a good office? This is land. You say it is your property. I say it is my property. Then what is the ideal situation? We go to the court and we are waiting for the court to give the final order. By that time, you're also dead, I'm also dead. Who will bear the fruits? Our kids. For our kids, why should we fight? Instead, can we resolve this dispute now? How do we resolve this dispute? Go to the good office. Which is the good office? Collector. Collector Saab, this is a piece of land. I am saying this is my land. This person is saying this is his land. But you are an impartial figure. You neither know me nor you know him. Can you please tell us whose land is this? Can you take up your records and see this land belongs to whom? The district collector will persuade you that this is not your land. This is his land. Even if you go to the court after 2 years, 3 years, 5 years, the court will give the verdict that this land does not belong to you. This land belongs to him. So you will end up losing not just your land, which you claim to be yours, you will also end up losing the money, which you will pay the lawyer. So the only beneficiary in this tussle is the lawyer who gets the money. Why do that? Resolve this problem. So we can approach alternate mechanisms. Instead of going to the court, let's first explore the alternate mechanism. We can go to a good office of the collector. We can go to the good office of the superintendent of the police and tell them that this is our dispute. Can you please resolve this dispute for us? If you are not satisfied by the resolution given by the collector or by the deputy superintendent of police, then we can approach the court. But mostly all the cases, majority of the cases would be solved with the intervention of the district authorities. If not, then we should go for arbitration. What is the difference? Arbitration. You and me have a dispute on this piece of land. We will now approach a third person, arbiter. And we have both agreed whatever decision will be given by this arbiter is binding on us. Do you agree? Yes. Do I agree? Yes. Then let's go to this arbiter and decide who is right in this case. And whatever decision is taken by the arbiter, that becomes binding on us. Which means we need to explore these alternatives. And we have such alternative, and that alternative is known as Lok Adalat. But unfortunately, it is not popular, particularly in northern India. It's popular in southern India. Cases are heard by the Lok Adalats. Lakhs of cases are disposed of by these Lok Adalats, but these are not popular in North India. So people are not aware that there is an alternate to going to the court. We can go to a Lok Adalat. And what is this Lok Adalat? It consists of a retired judge or a sitting judge, an advocate, a social activist. There is a case which is pending before the court, and there is a case which has not reached the court yet. What is the difference? There is a matrimonial dispute between husband and the wife. Now, ideally, where do we go? Go to the court. My lord, we need divorce. She needs divorce. I do not. I need divorce. She does not. Please decide. That means there is a case which is pending in the court. When this case is filed in the court, I need to have a lawyer. Other person will also need to have a lawyer. And at the same time, you have to pay fee in the court as well. If you want, you can withdraw this case from the court and you can approach to Lok Adalat instead. Whatever fee you had paid the court, that fee will be refunded to you. And in this Lok Adalat, you are not allowed to have a lawyer. That means if you and your spouse has a dispute, you have both filed a case in the court. Now, if you want to withdraw this case from the court will refund you the fee. And when you approach to Lok Adalat, you don't have to even bring your lawyer. So no lawyers are allowed. That means you will save money on that as well. But what if this case has not reached the court? Even then, you can directly approach to Lok Adalat. And once you approach the Lok Adalat, you don't have to pay any fee. You don't have to bring in any lawyers. This Lok Adalat, which is a 3-member body, it will hear your argument. It will hear her argument as well and ultimately take a decision. And whatever decision they take is binding on you. Lok Adalats take up only civil cases, not criminal cases. Because in criminal case, the state is involved. And the state has to punish one individual. In Lok Adalats, there can be a compromise. Compromise in the sense you give him something, he gives you something, and then resolve this matter so that you don't have to approach the court. So some sort of compromise is arrived at in these Lok Adalats. But there can be no compromise in a criminal case. You can't say, I murdered you, but now take this money and let me go. That cannot happen. I killed somebody, I raped somebody, and then take this money and go. That cannot happen. So in murder cases, in criminal cases, there is no compromise. We have to punish you. But in civil cases, there can be a compromise, give and take. That's how the disputes will be resolved. The only criminal case which can be heard by this Lok Adalat is a check bounce case. What is check bounce case? I bought some items from you. I gave you a check. Go and encash this check. But the value of the check is 10 lakh rupees. You approach the bank, give me 10 lakh rupees. I have the check. There is no money in the bank, which means the check has bounced, which means I fooled you. This is a criminal case. And this criminal case you can file in Lok Adalat. And this is the only criminal case which can be filed in Lok Adalat. Otherwise, Lok Adalats hear only civilian cases, civil cases. So what is the solution? When we say, I'll see you in court, which means if there is no other option but to approach the courts will always be overburdened with the cases. We will never resolve the pendency of the cases. Instead, what we need to do, we need to explore alternatives to dispute resolution. One such alternative is good office. One such good alternative is Lok Adalat or arbitration. Similarly, in Australia, there is a provision of electronic filing of cases, unlike in India, where there is huge amount of paperwork involved. And that's what I told you. Lots and lots of paper is involved. Leads to deforestation, is not environment friendly as well, but at the same time, it causes the delay. District court gave me the verdict and said you are guilty. I have to approach the high court, but I'm waiting for the typed judgment. Once I get this typed judgment, then I have to approach the high court. High court also gives me a verdict, but I am waiting for this typed document. Then I can approach the Supreme Court. So it's a delayed process. Instead, we can go for electronic filing of cases, digital filing of cases. Manual work is not involved. And something that we saw during COVID-19, virtual hearings. Virtual hearings in the sense, there are some cases where physical presence is necessary. Constitutional cases, federal disputes, where you need the presence of the lawyers on both the sides, physical presence, so that we can understand the case better. But there are lots and lots and lakhs of cases involving matrimonial disputes, involving petty crimes, involving civilian matter, land dispute, property dispute, contract violations. All these cases can be virtually decided by the courts. Virtually in the sense that there are judges, let's say on Zoom platform. We will not use Zoom, we will use a proper platform. We will use that platform because right now there is a delay because of this as well. I have to approach the court. I have to bring in witness from one part of the state to another part of the state where we have a high court. So it is time consuming as well. It leads to delay as well. And then the lawyer says, sir, can you please adjourn this session today? Why? Because our witness, he's stuck in Bangalore traffic. He cannot come. That is why we need to adjourn this. Ask him to join virtually, which won't lead to delay. So virtual hearings of cases, at least some cases should continue. That will resolve, that will reduce the pendency of the cases. Certain countries have adopted the system of discovery system. What is this discovery system? Listen to me carefully. You and me have a dispute on this piece of land. You say, I'll see you in court. I say, I'll also see you in court. Then we bring in our lawyers. You bring in your lawyers. We approach the court. And then the court will take its own sweet time to decide who is the real owner of this piece of land. Instead, can't we share the evidence that we have? So if you're saying this is your piece of land, show me what evidence you have. My lawyers will look at this evidence. I am telling you this is my land. My lawyers will share evidence with your lawyer. And then both these lawyers are sitting with each other. Yeah, he's right. This is exactly his land. So even if we go to the court will not hear this matter. The court will not rule in our favor. Then what do? Let's have a compromise. You have to pay me money. So I will take my money. But let's have a compromise. Ask him, give us few lakh rupees, and we will withdraw this case. So that discovery system, where both parties are able to examine the evidence that you have, it will reduce the number of cases reaching the court. That is something that we need to follow in India as well. Similarly, over a period of time, various committees have been set up to look into how can we resolve the pendency of the cases. And almost all of them have given similar set of recommendations. Constitute more number of benches. That means we have district courts, have more judges. More judges means more benches. More benches means more cases will be resolved. Increase the number of judges. The judges to population ratio, which is currently at 10.5, should be increased to 50. Computerize the entire judicial process, use of technology, and bunching of similar cases and conducting their hearing under one bench. One bench in the sense, there are hundreds of cases involving the same matter, property dispute. There are hundreds of matter pending in the district court on the same matter. And what is this matter? Motor vehicle insurance. Can't we do one thing? We will club all these cases and we will get them heard by the single bench. So similar cases should be bunched together and heard by a bench. So this bench will hear property disputes. This bench will hear motor vehicle insurance, all the motor vehicle insurance cases. All of you come together today. We will hear this case in one go. That means arguments may be same of almost all the cases. The insurance company is denying you insurance. That is the fundamental point. Whether insurance should be given or not, these are the guidelines. And on that basis, you have to pay the compensation. You have to pay the insurance benefit. That is something that we should do. But something else has happened over a period of time. In 2019, gang rape and murder took place in Hyderabad. There was a girl student, she was gang raped and she was then murdered as well. There were 4 people who were accused. Who were these individuals? These were accused. These were not guilty. These were accused. And normally, once you are arrested for a crime, then for investigation purpose, you are taken to the scene of the crime, where the crime was exactly committed, the place where the crime was committed, so that you can tell us where the crime was committed, so that you can show us evidence, so on and so forth. These 4 men who were accused of committing the crime, they were taken by the police to the scene of crime. And then the police alleged that these 4 accused, they tried to run away, and ultimately we had to shoot them, and ultimately they got killed. Most of the people said this was a fake encounter. Just like one criminal who was basically from Uttar Pradesh was arrested in Ujjain in Madhya Pradesh, Mr. Dubey. He was then brought to Uttar Pradesh. And then in Bollywood style, the car in which he was traveling turned turtle, and then the police said he tried to run away and he was shot dead. People said it was a fake encounter. These 4 accused of committing rape and murder of the girl from Hyderabad, they also were allegedly running away, fleeing, and the police shot them dead. It clearly seems that this is a fake encounter. Because even if they were running, you shoot them in the leg, don't shoot them to kill. Why can't you run after them and arrest them? You have the car, you have the vehicle, they are running on their feet. You run, you drive and arrest them, but it didn't happen. The problem is, people supported it. People in Hyderabad supported this. People in UP supported this. Why? Because the people realize that justice delayed is justice denied. Which means if these 4 people were arrested, it would have taken a lot of time for the judiciary to decide whether they are guilty or innocent. And after that, they will game the system and they will never be hanged. Look what happened with the rapist of the Nirbhaya. They were arrested, they were prosecuted as well, but they were keeping on. One, the court took a lot of time to decide whether they are guilty or innocent. Then they would file mercy petition after mercy petition, review petition, then curative petition, so on and so forth. So people got frustrated that our judicial system is so delayed that the best way to overcome this problem is kill the accused. Kill the accused. They're only accused. They're not convicts. Maybe they're innocent. Maybe. We don't know. Maybe they're innocent. Maybe the real murderer, the real rapist is still roaming around openly today. But this public support to these extrajudicial killings, because judiciary can say you should be killed, you should be hanged. But if judiciary is not saying, who is saying you are guilty? Police. And the police is killing you. It's an extrajudicial killing. This widespread support by the people for these extrajudicial killings, it is a symptom, an extreme symptom of increasing trust deficit between the citizens and the justice system. So we can say if the cases are pending in the court, it is no longer a judicial problem. It is a social problem. It is morphed into a social problem because people are now saying it is good for the police to take law in their own hands because we expect police to give quick justice. We don't expect judiciary to give quick justice. This prospect of delayed justice is one of the driving factors of this trust deficit, prompting people to support extrajudicial actions. This shows that the problem of judicial delay has morphed into a social issue with potentially terrifying ramifications for India's constitutional and democratic structure. Rule of law would say judges can decide whether you are guilty or not the executive, not the police. So, this support of the public for these extrajudicial actions, for these fake encounters, it is basically the symptom of the trust deficit that people have, that citizens have on the judiciary, that they will keep on pending these cases, piling up of the cases, and justice delayed is justice denied. What can be the conclusion? There are 44 million cases clogging India's district courts. Nearly 21% of these cases have been pending for 5 years or more. The issue of judicial backlog and delay is widely acknowledged and extensively written about, but it seems to be nowhere close to being resolved. Today, a litigant, somebody who approaches the court, who files a case, can be stuck in the court corridors for 20 years if a case goes all the way to the Supreme Court. I filed a case in the district court, not happy, go to the high court, not happy, go to the Supreme Court. And this entire process may take 20 years. J. Jayalalitha's case took 22 years to be decided. The original litigant may not be alive by the time the apex court, the top court, the Supreme Court resolves this issue. It is a stretch to describe any verdict given after 20 years as justice. After 20 years, you will decide that I am not guilty. I have lost my 20 years, the prime years of my youth. So you can't call after 20 years judgment justice. Justice delayed is justice denied. Now, high courts. I told you we have discussed one aspect of high courts when it comes to the prelims exam. But when it comes to the mains examination, there is one important topic that we have to discuss. That we will discuss after the break. Okay? Okay. Let's meet at 7:50 and we will discuss the remaining part of judiciary and then we will initiate the discussion on elections. If any state is bifurcated, then is there a necessity to make high court for that separate state? No, it's not necessary. Initially, when Andhra Pradesh was bifurcated, there was a common high court, but later on, a separate high court was provided for Telangana, but it is not necessary. Okay, now let's look at high courts. And the question is, the jurisdiction of our high courts has been subject to relentless attack. What is this concept about? For example, we have 42nd Constitutional Amendment Act, 1976. What it did, it added two more articles to the Constitution, 323A, 323B, which deals with tribunals. 323A talks about administrative tribunals. 323B talks about tribunals on other matters. What is a tribunal basically? It's a quasi-judicial body What is a quasi-judicial body? Which means some members are from judiciary, some members are from administration, which means bureaucrats, for example. That means this tribunal is not a completely judicial body because there are some members from the administration. It's not a completely administrative body because some members are from the judiciary as well. And they decide on some matters. And which are these matters? For example, if the case goes to the High Court, then it goes to the Supreme Court. Instead, can we have a matter that on these matters, instead of going to a regular court, you can approach a tribunal. And then this tribunal will give an award. And when this award is given, then you can file an appeal against this award as well. But initially, you should go to a tribunal. Why? Because we will reduce the burden on the High Court. So how can we reduce the burden on the High Court? For that, we should have the tribunals. Article 323A talks about tribunals on administrative matters. And which are these administrative matters? For example, CAT at the union level, SAT at the state level. What is CAT? Central Administrative Tribunal. What is this tribunal? If you are member of All India Services or Central Services, if you are an officer of the central government, any dispute that you have, whether it is related to your salary or increment or promotion or your removal or your dismissal or any disciplinary action is taken against you by your department, instead of going to a regular court, you can approach the Central Administrative Tribunal, which will have members from the administration as well as the judiciary. And whatever award they give, that will be the decision of the tribunal. You can challenge this award in the Supreme Court later, but initially you can approach the CAT, Central Administrative Tribunal, which means less and less number of cases will reach the high courts, which means the burden on the High Court will be reduced. 42nd Amendment 1976 talks about two types of tribunals. One is on administrative matter, administrative tribunals such as Central Administrative Tribunal, State Administrative Tribunal. But Article 323 talks about other tribunals, tribunals on other matters. What can be the other matter? For example, Income Tax Tribunal. You have a dispute on the income tax. The tax authorities say your tax liability is 1 lakh. You are saying I have paid the tax. Instead of going to the court, you will go to the Income Tax Tribunal. on elections, tribunals can be set up, which means we can have a separate system of tribunal where all election related cases can be filed. Right now, it is not in existence. You still go to the High Court, but it is possible to set up a tribunal for election disputes. That comes under Article 323B, which talks about tribunals on other matters. Then what is the issue? The issue is Tribunal Reforms Act. It was passed in the year 2021. And this matter is challenged before the Supreme Court. What are the challenges? This law has included those provisions which were previously struck down by the Supreme Court as unconstitutional. What is the history? 2017 Finance Act was passed. Basically, money bill was passed. Budget, it talks about appropriation bill, it talks about finance bill. First appropriation bill is passed, then finance bill is passed. This is Finance Act. This Finance Act, which was passed in 2017, abolished some tribunals and reduced the number of tribunals in India to 19. Initially, there were 26 tribunals. Now this number was reduced to 19. And it is this Finance Act which empowered the executive. That what executive you can do, you can make rules. Rules regarding what is the age criteria for those appointed as the chairperson and members of this tribunal. What is their eligibility? What is their term? What is their tenure? For that, who has the power to make rules? Executive. And executive made rules. And these rules said chairperson and members, they will be appointed for 4 years. 4 year will be the term. Age limit for a chairperson is 70 years. Age limit for a member is 67 years. These members, when they are appointed, they are appointed by the central government. But these members, minimum age is 50. And who will appoint these members? For that, we will have search cum selection committee. Who are the members of the search and selection committee? Chief Justice of India or a judge nominated by him. And this person will be the chairperson of the search and selection committee. It will have 2 secretaries nominated by the center. It will have a retired Chief Justice of a High Court or a sitting judge as another member. And it will have 1 secretary in charge of the ministry under which the tribunal is established. Clear? So this is a tribunal. Let's say, for example, this is Film Certification Appellate Tribunal. What is Film Certificate Appellate Tribunal? For example, we have movies in India. Now, these movies are to be certified by Central Board of Film Certification, CBFC, which is popularly known as the Censor Board. Although it's not a censor board, it's a certification board. What is a censor board? Censor board will tell you, don't make this movie. Make it like this. Remove these portions. That's the job of the censor. But CBFC ideally is not a censor board, it's a certification board. Certification board in the sense, you have made a movie and we will now certify which age group will be able to watch this movie. For example, if there is a lot of violence, if there are sexual themes and overtones in this movie is eligible to be watched only by those who are above the age of 18, adults. That means this movie will be given a certificate. But if it's a comedy movie, family movie, anybody can watch, it will be given U rating, universal. That means anybody can watch this movie. If this is a movie, but it requires parental guidance as well, that means above the age of 13, parents should accompany so that parents can tell their kids, this movie is only for entertainment purpose. Don't keep fighting with your sister or don't fight with your friends. This is not how you should fight. So parental guidance is required when these kids are exposed to some violent movies. So these certificates are issued. What if this certificate is not issued? The film producer, the film director can approach the Film Certificate Appellate Tribunal. Sir, the movie has been made. It was about to be released, but CBFC says we will not issue you a certificate. Or CBFC has given the certificate of A, but we need universal certificate so that anybody can watch this movie. Because if the movie is certified A, which means those below the age of 18, unless and until they are accompanied by their parents, they cannot watch the movie, which basically means number of people watching this movie would be less, because less than 18, they cannot come on their own to watch the movie. So ideally, these film producers and directors, they would ideally want a universal certificate to be given. What if it is not given? You approach the Film Certificate Appellate Tribunal. And whatever decision is taken, then it becomes your decision. You can release your movie. But now the point is, how should the members of this Film Certificate Appellate Tribunal be appointed? How should be the chairperson appointed? For that, the rule said there should be a search cum selection committee. The chairperson and members of tribunal shall be appointed based on the recommendations of this search and selection committee, which will have Chief Justice of India as the chairperson or a judge nominated by him, which will have two secretaries of the central government nominated by the government, Secretary of Economic Affairs, Secretary of Finance, Secretary of Information and Broadcasting, any secretary nominated by the central government. It will have a retired judge of the High Court or a sitting judge of the High Court as another member, and it will have one secretary of that ministry under which this tribunal is constituted. And this person will have no voting right. No voting right in the sense, you cannot decide whether this person should be appointed or not. Because when these members will sit to appoint members, to recommend members to these tribunals, they will have the voting right. I'm voting for A, I'm voting for B, I'm also voting for A. So A can be sent for appointment. This secretary who is in charge of that ministry under which the tribunal is to be constituted will not have the voting right. Sir, what does that mean? For example, FCAT is to be established, members are to be appointed. FCAT comes under Ministry of Information and Broadcasting. So the secretary of the Ministry of Information and Broadcasting will also participate in the meetings of search cum selection committee, but will not have any voting right. The Supreme Court struck this down in Madras Bar Association versus Union of India. In this case, the Supreme Court struck this down, saying independence of judiciary has been violated. Why independence of judiciary has been violated? Because majority of the members of this search cum selection committee, they are part of the executive. They're not part of the judiciary. And these tribunals, what do? They give justice. And since they give justice, since independence of judiciary is important and is part of the basic structure, the composition of this search and select committee is such that it is tilted in favor of the executive, which violates independence of judiciary. So this is struck down. But the same committee which was struck down by the court in Madras Bar Association, same committee was created by the Tribunals Reforms Act of 2021. Now this matter is before the court. My lord, previously, what you struck down, the same search and selection committee has been made by the Tribunals Reforms Act. That's question number one. Question number two, the Supreme Court had said that make minimum age 40. When you're appointing members to the tribunals, when you're appointing chairperson to a tribunal, minimum age to be appointed should be 40. Who said this? Supreme Court. When? In Madras Bar Association versus Union of India. But this Tribunals Reforms Act, it says no, the minimum age is 50, violating the judgment of the Supreme Court in Madras Bar Association. That is why the matter is before the court. Not just that. The Supreme Court had said advocates with 10 years experience should also be eligible to be appointed in these tribunals. The Tribunals Reforms Act makes no such provision. Similarly, this law, it talks about that the tenure of the chairperson and the members is 4 years. Supreme Court had said in Madras Bar Association that this term should be 5 years. Long story short, Tribunals Reforms Act of 2021 have included those provisions which previously were struck down by the court in Madras Bar Association case. How can those provisions which were struck down by the court previously be included in a law passed by the parliament? That is why the matter is before the court. But these tribunals, they are violating the jurisdiction of the high courts. How? Let's discuss. Independence of judiciary is part of the basic structure of the constitution. Right or wrong? Right. So when you approach the high court, when you approach the Supreme Court, you get a sense that high court and Supreme Court is independent, because the judiciary members, they are appointed by the president, but they have a well-defined tenure till the age of 65, till the age of 62. They do not hold office during the pleasure of the president. So they have some independence. Their salary is charged on the Consolidated Fund of India. But when it comes to a tribunal, tribunals will be under the influence of the executive, because the chairperson and members of the tribunal are appointed by center. They can be removed by the center as well. Their term, can they be reappointed or not, is decided by the center. When these members of the tribunals, they are appointed by the center will have more control over these members. So as an idea, the creation of more and more tribunals, it is against independence of judiciary. That's problem number one. Problem number two is, in these tribunals, some tribunals were removed, abolished. For example, FCAT, Film Certificate Appellate Tribunal. This has been abolished now. So now there is no FCAT. So if there is a film producer who is facing a problem that CBFC is not giving a certificate, you rather approach the High Court and not Film Certificate Appellate Tribunal, because this tribunal has been abolished. That means tribunals can be set up, tribunals can be abolished by the central government at any point in time. But high courts cannot be abolished. Supreme Court cannot be abolished. So high courts, they have their independence. So we should rather have more high courts in India. Tribunals should be less, because they are under the influence of the executive. But not just that. The also point is, we have, for example, SEBI, Securities and Exchange Board of India, which is basically a stock market regulator in India. stock markets are regulated by SEBI. If there is a dispute on stocks, for example, I purchase stocks of a particular company, but then there is a dispute, I have to approach a tribunal, and this tribunal is in Mumbai. What if I am from Guwahati? What if I am from Chennai? I have to come all the way from Guwahati, all the way from Chennai to come to Mumbai and appear before the Securities and Exchange Board of India tribunal and then hear my case, argue my case. Instead, why can't I approach the High Court? So when you are excluding high courts, when you are asking people to directly approach the tribunal, but tribunals are not found everywhere in India. High courts are found everywhere. For example, we have National Green Tribunal, NGT. It sits in Delhi and it has 4 different benches. That means still majority of the people in India cannot approach the National Green Tribunal, which basically means these are inaccessible to a massive majority of Indian population. And that is how this blatant tribunalization has affected the jurisdiction of the high courts. So there is one theory which says tribunals should be abolished and we should restore the primacy of the high courts in India. Not just that, the most important point, high courts in India can hear all types of cases, whether it is property dispute, whether it is fundamental rights, whether it is a constitutional case. It can hear all kinds of cases. In fact, the first Constitutional Amendment Act was triggered because of Patna High Court order, something we have discussed. It was Patna High Court which said Land Reforms Act is unconstitutional, Zamindari Abolition Act is unconstitutional. So high courts in India are created as such a powerful institution that it can hear all kinds of cases. But now we are telling an high court that there are some cases which you cannot hear. Administrative matters, don't hear them. For that we have CAT. Environmental matters, don't hear them. For that we have National Green Tribunal. Income tax related cases, don't hear. For that we have Income Tax Appellate Tribunal. Railway related cases, don't hear, because for that we have railway boards. That means we are not empowering the high courts to hear all types of cases because we have created more and more tribunals. A bigger problem is created when this judge, listen to me carefully, when this judge of a high court is promoted and appointed as the judge of the Supreme Court. When I was in high court, income tax related cases did not come to me. Environmental cases did not come to me. Stock market related cases did not come to me. Administrative related cases did not come to me. But now I have been promoted and appointed as the judge of the Supreme Court. Here, I receive all types of cases. I receive environmental cases. I receive tax related cases. I receive railway related cases. I receive environment related cases. But when I'm hearing all these cases, I don't have the expertise to deal with these cases because I was never exposed to these cases when I was in the high court. And that is why people say this blatant, this rapid tribunalization, where you are creating more and more tribunals, this process must end because the high court's jurisdiction has come under relentless attack because of these tribunals. That completes our discussion on judiciary. The topic judiciary is over. Now we will have to deal with elections. But if you have any questions, let me know. Then we will start with elections. At present, tribunals exist. There are 19 tribunals which exist in India. Okay. Now let's look at elections. Elections, the biggest festival in India's democracy. So the biggest festival may not be Holi, Diwali, Baisakhi, Christmas, Eid, the biggest festival in Indian democracy is elections. And through these elections, if these elections are free and fair, we can say democracy exists in India. Elections should not only be held, elections should be free and fair. Free in the sense anybody who is eligible should be allowed to contest elections. Not like in Russia, where anybody who is against Mr. Putin is not allowed to contest elections. So there also elections take place, but they are not free. There are elections which happen in Pakistan also, but they are not fair, because the army decides who is going to be the prime minister. I like Imran Khan today you are the prime minister. I don't like him, now Shahbaz Sharif becomes the prime minister. Today they may like someone else, and that someone else becomes the prime minister. So elections are held in Pakistan also, but they're not fair. They may be free, that means anybody can contest, but they're not fair. The very presence of free and fair elections can be assumed that it's a stamp that a country is democratic. Elections should not only be free and fair, elections should be periodic as well. It should not be that elections are held today and now after 20 years we will have another elections. That means this country is not democratic. If there are 10 countries in the world and we have to identify which of these countries are democratic, for that we need to know if the elections are free and fair, if the elections are held regularly on a periodic basis every 5 years, then that country is democratic. And elections are also a tool of accountability. 2004, Bharat Uday, India's shining campaign, was launched by the then Prime Minister Atal Bihari Vajpayee. People saw through that and said India may be shining in urban India, but the rural India, the Bharat, is still struggling. There is farmer distress, there are farmer suicides, there are no roads. So India may be shining. Bharat Uday is there in urban India, but not in rural India. What did people do? They removed Mr. Vajpayee as the Prime Minister. So elections are a tool of accountability. The members who are elected, they are held accountable by the people every 5 years through this process known as election, through this device known as elections. Then came Dr. Manmohan Singh. He did something spectacular. Forest Rights Act was passed. MG Narega was passed. Right to information was passed. Right to education was passed. And Indo-US nuclear deal was signed in the year 2008. So, and there was a global crisis as well, economic crisis in 2008. And we can say that if there were two countries which were less affected or least affected by this global economic crisis, one was China, the other was India, led by economist Dr. Manmohan Singh. People loved him. And in 2009, even bigger majority was given to Dr. Manmohan Singh. It was Dr. Manmohan Singh's election. In the previous election, Congress could get 145 odd seats. In the next election in 2006, the Congress got 206 seats. That is thanks to Manmohan Singh, because people trusted him. But then there was policy paralysis. Lots of scams, decisions were not taken. And ultimately people said enough is enough. Then came a man from Gujarat who said, Mitro, I will change everything. You give me the opportunity. People loved him and voted for him in 2014. Loved him even more in 2019 and voted for him again. Despite the fact that one opposition leader said, Chokidar chor hai. People said, you may be thief, but not our prime minister. We will vote for him again. And in 2019, he was re-elected. In 2024, people will hold the government accountable again. If people are happy, they will vote for him again. If not, then you will be voted out. But elections, and listen to me carefully, this is the most crucial point. Elections do not only elect a government. Elections appoint an opposition as well. In Gujarat, elections were held. Elections were held not only to see who gets the majority, who forms the government. Elections were also held so that people can now decide who is best suited to play the role of an opposition. If the Congress has been unable to play the role of an effective organization, Congress will be replaced by Aam Aadmi Party. So now we are seeing in India that elections are not only to select the government, to elect the government, but also to elect the opposition. If the Congress in 2024 is unable to give a voice to the people that we can play the role of a credible opposition, it will be removed even as a principal opposition political party. Someone else will occupy that space, whether that is Aam Aadmi Party, whether that is Mr. KCR, whether that is Mr. Stalin, or whether it is Ms. Mamta Banerjee. Anybody, somebody else can occupy the space of a principal opposition party, because people will choose not only those who are part of the government, not only the government, but people will choose the opposition as well. Elections, one of the biggest festival in India's democracy. The very existence of free and fair elections, the very existence of periodic elections points to a fact that India continues to remain a democracy, a vibrant, flourishing democracy. We may have problems, but we are democratic. And elections, they are not only a tool of accountability. Through elections, people hold their elected representatives accountable. But people elect the government and people elect the opposition as well through these elections. Election results are being declared today. In Meghalaya, we will have to see who forms the government. But in Meghalaya, we will have to see whether the second political party, the second highest vote getter or seat getter, whether that is All India Trinamool Congress or whether it is the Congress party. So people in Meghalaya will not only elect the government, but will also elect the opposition, who is best suited to play the role of an effective opposition. There are some constitutional provisions regarding elections. We will look at these constitutional provisions one by one. I'll just give you an idea about these constitutional provisions. Then we will elaborate all these constitutional provisions one by one, and then elections chapter is over. Article 324 creates a constitutional body known as the Election Commission of India. Constitution says superintendence, direction, conduct, control of all elections will be vested in the body known as the Election Commission of India. What is this Election Commission? What is the superintendence, direction, conduct, control? How are these members appointed? How are they removed? What are their powers? We will discuss slightly later. But here, just keep in mind that Article 324 creates a constitutional body, and that body is vested with the role, with the power to conduct elections in India. And that body is the Election Commission of India. Article 325 talks about a common electoral roll. What is this common electoral roll? Let me take you back to 1909. What happened in 1909? Morley-Minto reforms. Morley was the Secretary of State for India. Minto was the Viceroy, the Governor General. Some reforms were made. And what were the reforms? Communal electorate. What was that communal electorate? We will give Indians the right to vote, to elect their representatives in the assembly, but we will reserve some seats for Muslims. That means there are some seats in the legislative assembly which are reserved for Muslims, and only Muslims can vote for these seats. Others cannot. So the system provided was a communal electorate system. That means one electoral roll for Muslims. Only Muslims can vote, only Muslims can elect their representatives who can be Muslims. For others, it is a separate electoral roll. Later on, the separate electoral roll system was extended to Sikhs, was extended to Christians, was later on extended to Dalits as well. And this is where the father of India, the father of the nation of India, Mahatma Gandhi, went on fast unto death. He said, if you are creating Dalits as a separate religion, and you are giving them separate reservation, only Dalits can vote, only Dalits can contest elections from these seats, then Hinduism will collapse. And this is something that I will not agree to. Then there was a pact known as Pune Pact between Mr. Gandhi and Dr. Ambedkar, where both of them agree that we need to increase the reservation for Dalits in Legislative Assembly. Only Dalits can contest elections, but votes can be given by non-Dalits as well. That means Hindus, Christians, others, Muslims, they can also vote to elect a Dalit representative in the Legislative Assembly. But we will not have a system where only Dalits can vote to elect a Dalit. That is something that is not acceptable. And that was part of the Pune Pact. But long story short, what happened in 1909, it ultimately sowed the seeds of partition, which led to the partition of this country in 1947. Where some seats are reserved for Muslims, only Muslims can contest the seats, only Muslims can vote. Some seats are reserved for Sikhs, some seats are reserved for Christians, only Christians can contest elections, only Christians can vote. This system was disbanded when the Constitution was enacted, and Constitution said we will have a common electoral roll. No person is to be ineligible for inclusion to a special electoral roll on the grounds of religion, race, caste, or sex. That means there will be a common electoral roll. Nobody can be excluded from this roll only on the grounds of religion, race, caste, or sex. And nobody can claim inclusion in a special electoral roll. That means let's have a common special electoral roll where only Hindus can vote, only Hindus can contest elections. Such a system will not exist in independent India. Long story short, what is this electoral roll? There are voter lists. When these voter lists are prepared, all those who are above the age of 18, their names are mentioned in this voter list. Does this system create discrimination on the grounds of religion, race, caste, or sex? No. That means anybody who is above the age of 18, regardless of your religion, regardless of your race, regardless of your caste, regardless of your sex, is included in this voter list. And they will have the right to vote to elect their representatives. But sir, what about reservation for SCs and STs in Lok Sabha, in legislative assemblies? Is that not violative of Article 325? No. Why? Because even if there are seats reserved for SCs and STs in Lok Sabha, who can contest these elections? Only those who are from reserved category. But who can vote? Anybody can vote. Anybody who is above the age of 18. That means it is not like what happened in 1909, where if the seats are reserved for SCs, only SCs can contest and only SCs can vote. No. If this seat is reserved for SC, this constituency is a reserved constituency. Yes, only SC can contest election. But who can vote? SC, non-SC, ST, general category, men, women, anybody can vote. That is a common electoral roll under Article 325 of the Constitution. And Article 326 talks about a universal adult suffrage. When India was giving itself her constitution, there were different columnists, different writers who started writing columns, and as if they were writing obituaries of India, some condolence messages for India, that this is an experiment which is bound to fail. India is going to collapse. Why? Look at what India is doing. It is giving a right to vote to every adult, including women, including illiterates, including those who have no property, including those who are from a different caste or different race. What is India doing? India is bound to collapse. That's what Western columnists started writing. But India did not. And that was a leap of faith. We have faith in our people that every adult, initially, the voting age was 21 years. 1989, it was reduced to 18 years. Rajiv Gandhi was the prime minister. But every adult, regardless of your religion, regardless of your caste, regardless of your sex, regardless of your educational qualification, regardless of your amount of property that you're holding, regardless of your status, you will have the right to vote. The so-called big democracies of the world, United States of America, they gave voting rights to women in 1920s. So gave United Kingdom in 1921 to women. Switzerland gave voting right to women in 1977. These European countries, initially they would give voting rights only to men, and that to white men. So there was racial discrimination. Blacks were not given right to vote. Initially, they would give voting right only to educated. They thought, how will an uneducated and illiterate person exercise right to vote? What will he or she know? Only those who had some amount of property, they were allowed right to vote. But India gave universal adult franchise, adult suffrage. Anybody who is above the age of 18, regardless of your religion, race, caste, sex, place of birth, whatever it is, we gave right to vote to everybody. That's Article 326. Article 327 and 328 are mostly similar. Similar what? But there is one minor difference. What is the similarity? Article 327 empowers the parliament. That parliament, what you can do, you can make a law regarding elections to the legislatures. Parliament has done that. Passed Representation of the People Act 1950, passed Representation of the People Act 1951. What is the difference between the two laws? We will also discuss in elections chapter. But Article 327, what does it say? It gives power to the legislature, power to the parliament. That their parliament, what you can do? You can enact laws. Through these laws, what you can do? You can govern the conduct of elections in India. Whether the elections are to Lok Sabha or Rajya Sabha, whether elections are to Legislative Assembly or Legislative Council, you have the power to make a law. You have the power. You have that right. Similar power is given to state legislatures under Article 328. That under Article 328, state legislature has the power. What you can do, you can pass a law. Through this law, what you can do, you can govern the conduct of elections to your own legislature. Provided Parliament has not made such a law. So what are we discussing? Elections chapter. Article 324 creates a constitutional body for the conduct of elections in India known as Election Commission of India. Clear? What is that role? We will discuss. Article 325, it talks about a common electoral roll. That means the voter list is common. Common in the sense, we will not have a separate voter list for Hindus, Christians, Buddhists, Jains, Parsis, so on and so forth. We will have a common electoral roll. And any adult can be included in this voter list, regardless of your religion, your race, your caste, your sex. Then Article 326 talks about universal adult franchise, which means right to vote. Which means right to vote is what type of right? It is a constitutional right. What is a constitutional right? That means a right given by the Constitution. That every adult above the age of 18, you have the right to vote. And this right also includes right to contest elections. Right to stand for elections is also your constitutional right under Article 326 of the Constitution. But Article 327 and 328 are mostly similar. 327 empowers the parliament. What parliament you can do? You can enact a law, and through this law, you can govern the conduct of elections to legislatures. Whether the legislature is Lok Sabha or Rajya Sabha, whether the legislature is state assembly or state legislative council, you have that power. But under Article 328, state legislatures are also given the power that Karnataka legislature, come here, you can also pass a law. And through this law, you can govern the conduct of election to your own legislature, provided Parliament has not passed any law. If Parliament has passed a law for the conduct of elections to Karnataka legislature as well, then it is that parliamentary law which will prevail. If Parliament has not passed any law, then you are empowered. You can pass a law to define the conduct of elections to your own legislature. But since Parliament has already passed a law known as Representation of the People Act 1950, known as the Representation of the People Act 1951, which we will discuss. Since Parliament has already passed the law, that is why state legislatures have not passed their own laws for the conduct of elections to their own state legislatures. Article 329, which is the last constitutional article which governs the conduct of elections in India, in this chapter elections, it talks about bar to interference by courts in electoral matters. There is an electoral matter, but there can be no interference by the court. In all the matters related to elections, electoral matters, the courts will not interfere. What are these electoral matters? Delimitation. What is delimitation? The entire country is divided into constituencies. Clear? For example, if we talk about Lok Sabha election, the entire country during Lok Sabha election is divided into 543 territories, known as 543 territorial boundaries, known as 543 constituencies. And from one constituency, one member will be elected and will represent that constituency in Lok Sabha. Clear? But how many people can elect one MP? There should be uniformity. Uniformity in the sense, if in Uttar Pradesh, for example, 1 million people are represented by one MP, and in Goa, 10,000 people are represented by one MP, what do you think is getting violated? One person, one vote. We are all citizens of India. So what is the value of my vote should be equal to the value of the vote of a citizen in Uttar Pradesh. But now we are seeing, or we may see, that if Uttar Pradesh has a big population, they should have more number of legislators as well. Because one person, one vote. Because here in small state, if 1 lakh people are represented by one MP, then if the population of Uttar Pradesh is 10 lakh, then it should be represented by 10 MPs, so that the value of vote of all the people of India is the same. That is why Constitution mandates that after every census is a decadal exercise carried out every 10 years. After every census, we should go for delimitation. Delimitation in the sense, if the census tells us that the population has increased, where has the population increased? In these states. In these states, we should increase the number of seats as well. And this process of redrawing the entire country or redrawing the constituencies, that process is known as delimitation. And delimitation was conducted. After the census of 1951, it was conducted in 1952. Then it was conducted in 1963. Then it was conducted in 1973. Then it was conducted in 2002 as well. But let's focus on these 3 delimitations. Because after every census, when we get an idea about the population of India, then proportionate to this population, we should increase the number of seats. Delimitation was conducted in 1952. Delimitation was conducted in 1963. Delimitation was conducted in 1973. So because of delimitation, in Lok Sabha, for example, the number of seats were 489. In 1963, it went up to 513. In 1973 delimitation, it went up to 543. That means as the population is increasing, so is the number of seats also increasing in the Lok Sabha. But in 1973, when delimitation was carried out, the southern states protested. Indira Gandhi was the prime minister. Madam Gandhi said, what? We protest. Okay, but why? What's the issue? Ma'am, after every census, when we get to know that the population is increased, we go for delimitation. Yes. Which means we reorganize the boundaries. Yes. Which means based on the population, we also increase the number of seats as well. Yes. But you are disincentivizing the southern states. Why? Because we have implemented family planning programs effectively. So our population is stabilizing. It is not growing exponentially. But look at these so-called Bimaru states. Which are these Bimaru states of North India? Bihar, Madhya Pradesh, Rajasthan, Uttar Pradesh. These Bimaru states, the population has not stabilized. Population is growing and growing exponentially. So when population is growing, the number of legislators from these states will also grow, will also increase. So Madam Gandhi, there will come a time where the southern states will be at a disadvantage, where we will have less representation in Lok Sabha and these northern states will have more representation in Lok Sabha. So you are basically disincentivizing us. Why have you implemented family planning programs? And you are incentivizing these insensitive states because they have been unable to control their population. Tomorrow their leaders will tell their members, their citizens, you should reproduce more. Reproduce 10 children so that from UP, if we have these many population increases, we will get these many seats in Lok Sabha. You are disincentivizing us, you are incentivizing them. Madam Gandhi said, don't worry, we will amend the constitution. Madam Gandhi, what is that amendment? Because constitution says after every census there should be delimitation. Yes, we will say no delimitation till 2001. That means 2001 census will be conducted. After that, we will have delimitation. And even if delimitation is conducted in 2001, no increase in seats till 2026. Why? This is 1976. This is 2026. How many years are left? 50 years. We hope that we will stabilize our population in the next 50 years. And in 2026, we would have stabilized our population. So till 2026, there won't be any increase in the number of seats, but there will be no delimitation till 2001. There can be delimitation after 2001, but it won't lead to the increase of the number of seats. Then delimitation was conducted in 2002. What was the need to conduct delimitation in 2002? There were two reasons. Reason number one, 2002 delimitation, it is also known as internal reorganization. What is this internal reorganization? For example, this is a state X. It has 1, 2, 3, 5 constituencies. Constituency A, B, C, D, E. Constituency A has 10 lakh voters. Constituency B, 20 lakh voters. Constituency C, 40 lakh voters. Constituency D, 50 lakh voters. Constituency E, let's say 30 lakh voters. Total 80, 120, 160, 170, 50, 90, 100, 150. Total is 150 lakh. But look at the discrepancy here. Within a state, there are 5 constituencies. But in one constituency, 10 lakh people are electing one representative. Same state, 50 lakh people are represented by one MP. Delimitation, when it was conducted and carried out in 2002, that was known as the internal reorganization. Internal reorganization in the sense, we will have the same state. The number of seats will still remain 5. But in every state, we will, in every constituency, we will have 30 lakh population. Look at the two pictures. Here, more people are represented by one MP. Here, less people are represented by one MP. Let's do the delimitation within that state. Within that state, number of seats will not increase because it is frozen till 2026. But what we will do, we will divide the population in such a manner that every constituency is represented by equal number of people. That was reason number one why delimitation was carried out in the year 2002. Reason number two was to increase representation of SCs and STs by reserving more seats for them. 1973, when the delimitation was carried out, there are seats which are reserved for SCs and STs. Let's say the number of seats is 59. These seats have been reserved for SCs and STs. Now the SC/ST population has increased over a period of time. In 1981, in 1991, in 2001. Sir, how do we know there is no caste census in India? That's what the demand of the Bihar political parties or some political parties is, that there should be a caste census. But listen to me carefully. The regular 10-year census that is carried out, it tells us what is the population of SCs and STs. But it does not tell us what is the population of OBCs. The demand for caste census by Bihar is not to identify how many SCs and STs do we have, because that is already known through the census exercise. They want to know how many OBC castes are there and what is their population. What is the percentage of population which belong to OBCs, other backward classes. So when we already know that the population of SCs and STs is increasing and has increased, now in 2002 it was decided that the seats reserved for them should be increased. Total seats will still remain 543. But the seats which were reserved for them, which were previously, for example, 59, now these seats will be increased to 89. Total number of seats will remain 543. But the number of seats reserved for SCs and STs, it will go up depending upon the 2001 census figures. These were the two reasons why census exercise was carried out. But who conducts this? Who carries out the census exercise? For that, there is a body known as Delimitation Commission. And Delimitation Commission is a statutory body. It is not a constitutional body. Once census exercise is carried out, then under Delimitation Act, which is the law passed by the Parliament, then under the Delimitation Act, a body will be constituted and this body will carry out delimitation. So it's a statutory body. And this statutory body is headed by a retired Supreme Court judge. It will have the Chief Election Commissioner. It will have the State Election Commissioner as well. And then they will decide, how do we reorganize the state? What is Article 329 saying? Bar to interference by courts in electoral matters. That means when this Delimitation Commission gives an award, this award cannot be challenged in any court of law. For example, for Jammu and Kashmir, when it was bifurcated into two union territories, Jammu and Kashmir and Ladakh, the Jammu and Kashmir Reorganization Act 2019 said, since a new state has been created, we need to carry out delimitation as well. And this delimitation will be carried out by the Delimitation Commission. This Delimitation Commission was headed by the former judge of the Supreme Court, Ms. Ranjana Desai. And then this Delimitation Commission said that we should increase the number of seats in Jammu and Kashmir. And we should increase the number of seats by 7. Jammu and Kashmir has 2 provinces. One is Jammu, the other is Kashmir. Delimitation Commission said 6 seats should be given to Jammu. 1 seat will be given to Kashmir. Despite the fact that the population of Kashmir Valley is more than the population of Jammu Valley. But even then, 6 seats were given to Jammu, 1 seat was given to Kashmir. Why? Because this Delimitation Commission said population alone is not the criteria. We have to look at the hilly areas. There are some areas which are hilly areas where the population is sparse. That means population is not large. It's a sparsely inhabited area, but the area is large. For this, we should provide additional seat. There are some areas which are close to the border areas. For example, Samba, for example, Katwa. These are bordering areas, bordering Pakistan. For them, we should give an additional seat. So different criteria was kept into mind, apart from the population, by Delimitation Commission. Criteria such as population, criteria such as hilly area, criteria such as bordering the foreign country, criteria such as the distance between the capital and that area. Various factors were kept into mind. And ultimately it was decided that 6 seats will go to Jammu despite less population. 1 seat will be given to Kashmir despite more population, because population alone is not the criteria. Can this award be challenged in the court? No. Why? Because under Article 329, there is bar to interference by courts in electoral matters. But sir, this matter had reached the Supreme Court. In fact, Supreme Court said delimitation is constitutional. Then how did this matter reach the court when Article 329 says this matter cannot go to the court? There's a difference. What is the difference? 2 residents from Srinagar in Kashmir, they approached the Supreme Court, but they did not challenge the award of the Delimitation Commission. They did not. They did not challenge, why have you given 6 seats to Jammu and 1 to Kashmir? They did not challenge on what criteria, on what basis you are reorganizing Jammu and Kashmir by giving 6 seats and by increasing it by 7 seats. No, award was not challenged. Then what was challenged? The very constitution of this commission was challenged. Petitioners argued, sir, my lord, why is there a different treatment for Jammu and Kashmir? I said, why? Sir, in another part of the country, throughout the country, delimitation will be carried out only after 2026. Why are we singled out and delimitation is carried out only in Jammu and Kashmir? And in fact, if the number of seats cannot increase in any part of the country, then why are you increasing the seats only for Jammu and Kashmir? So the award of the Delimitation Commission was not challenged. The very constitution, the very exercise of delimitation was challenged. And the Supreme Court said no, because since the state has been created, the states had been bifurcated, and now you are no longer a union, you are no longer a state, you are a union territory. So for states, we cannot increase the number of seats. We cannot go for delimitation till 2026. But you are not a state, you are a union territory. And Parliament has the right to decide on reorganization and delimitation for a union territory. And that is how delimitation is constitutional. Similarly, something happened. In 2008, in 2002, when delimitation was being carried out on the basis of the 2001 census, there were 4 states which protested: Arunachal Pradesh, Assam, Manipur, and Nagaland. They said, we don't want delimitation. They approached Guwahati High Court. They did not challenge the award of the Delimitation Commission. They challenged the very existence of Delimitation Commission to conduct delimitation in these 4 states. Why? Because they said, if the census of 2001 is the basis of delimitation, we think that this census of 2001 it has included a lot of illegal migrants as well. So if you make delimitation as the basis on census of 2001, we see that this census of 2001 includes a lot of illegal migrants as well. We don't trust the census of 2001. That is why they approached the Guwahati High Court, and President ultimately issued an order. President said, okay, these 4 states are excluded from delimitation exercise. That means the last time that this delimitation exercise was carried out in 2002, the final award was given in 2008. The final reorganization was done in 2008. There were 4 northeastern states which were exempted. And President, on the advice of the government, exempted these 4 states from delimitation exercise: Arunachal Pradesh, Assam, Manipur, and Nagaland. And at the same time, the president said that if tomorrow delimitation is to be carried out in these 4 states, it will not be done by Delimitation Commission, it will be done by the Election Commission of India. That points out to another interesting thing, is that delimitation cannot be only conducted by Delimitation Commission. Even Election Commission can carry out delimitation exercise in some states. That completes delimitation. Any questions? Let me know. Till census is not taking place, then what is the work of Delimitation Commission? Nothing. Delimitation Commission is set up as soon as we have to organize delimitation. Otherwise, it is not there. Delimitation Commission was set up once delimitation was to be carried out for Jammu and Kashmir. Now that will be abolished. The next time when a delimitation is carried out after 2031, because now next time delimitation will happen after 2026, which means after the census of 2031, which means then a new delimitation commission will be set up. Where is it mentioned that central government can do everything with union territory? That's mentioned in the Supreme Court verdict on delimitation. Supreme Court says what can be done, what cannot be done. If any dispute, approach the court, and the court has said, since J&K is a union territory, state parliament has passed a law to carry out delimitation. If there can be no delimitation in a state, that exists only for a state, not for a union territory. The award of the Delimitation Commission cannot be challenged in any court of law, which means if the Delimitation Commission for J&K has given 6 seats to Jammu, 1 seat to Kashmir, it cannot be challenged in any court of law. If you approach the court and say, this is not correct, this is not how it should be, the court will reject your petition. Unless and until, there is an exception, unless and until the Supreme Court invokes its special power, known as Article 142. If the Supreme Court wishes, it can issue an order under Article 142 so as to give complete justice. If the Supreme Court thinks that injustice has been done in this case, we will give complete justice. And under Article 142, we will say this Delimitation Commission award is not binding. But whether that will happen or not, that is anybody's guess. Bifurcation states delimitation is applicable. Not necessary. If the parliament wants, it can go ahead. For example, the petitioners in Jammu and Kashmir delimitation case had argued before the court that Home Minister said something in Lok Sabha. What? He was asked, should we conduct, is there any process, is there any proposal to conduct delimitation in Telangana? Because Telangana has now been carved out from Andhra Pradesh. The Home Minister said, no, we cannot increase the number of seats for Telangana because till 2026, there is a freeze, there is a ban on the increase of seats. The petitioners in J&K case said, since Home Minister has said this on the floor of the Parliament, which means till 2026 we cannot increase the seats, then why are you increasing seats for Jammu and Kashmir? The court said Telangana is a state, Jammu and Kashmir is a union territory. For union territory, the seats can be increased. Sir, is possibility in 543 seat increase in 2024 because Jammu and Kashmir seats increased? The number of seats from Jammu and Kashmir in Lok Sabha, that has not been increased. That's still the same, 5 seats. It is the number of seats for Jammu and Kashmir Legislative Assembly. Those seats have been increased. Those seats have been increased by 7. Okay. Now let's explain all these constitutional provisions one by one, beginning with Election Commission of India. We say Election Commission of India, which is a constitutional body under Article 324 of the Constitution. It says superintendence, direction, conduct, control of all elections, whether it is president's election, vice president's election, Lok Sabha, Rajya Sabha, Legislative Assembly, Legislative Council. Superintendence, direction, conduct, control of all these elections is vested with the body known as Election Commission of India. There are one type of elections which are not conducted and organized by Election Commission: local body elections to Panchayati Raj and municipalities. Those elections are organized by the State Election Commission. But all other elections are organized by the Election Commission of India under Article 324 of the Constitution. But what do we mean by superintendence, direction, conduct, control? For that, Election Commission of India has made various rules. For example, election conduct rules, 1961. Symbols order, 1968. Symbols order in the sense, Constitution says elections shall be organized by the Election Commission of India. On what basis? On the basis of the law passed by the Parliament. And Parliament has passed laws. Representation of the People Act 1950, Representation of the People Act 1951. But both these laws, they do not talk about the symbols of the political parties. Political parties should have a symbol. Symbol in the sense, hand of Congress, lotus of BJP. Even if those individuals, those citizens who are illiterate, they don't know how to read and write, but they would identify a political party based on their symbols, whether it is elephant, whether it is cycle, whether it is hand, whether it is lotus, whatever it is, whether it is broom of Aam Aadmi Party, which is being swept right now, whatever it is. So you identify the political party based on symbols. So Election Commission gave itself the power that we will allot symbols, we will reserve symbols for political parties, we can withdraw these symbols as well. If the political parties violate some rules, some norms, we can allot them symbols, we can remove these symbols as well. Matter went to the court. Sadiq Ali judgment. Matter went to the court again in another judgment. That judgment was Kanhaiya Lal Umar versus R.K. Trivedi. What was the case about? Listen to me carefully. My lord, Election Commission of India has the power to organize elections. Court said yes. But sir, this election conduct should be on the basis of the law passed by the parliament. That means Election Commission of India should not do anything, should not have more rules, should not create more regulations, apart from those rules which are mentioned in Representation of the People Act 1950, Representation of the People Act 1951. Sir, what are you trying to say? Sir, Election Commission has introduced rules known as Election Conduct Rules 1961. They have introduced order known as symbols order. They can allot symbols, they can withdraw symbols as well. This goes against the law passed by the parliament. And in fact, this is the law passed by the Election Commission. But lawmaking is the job of the legislature. How can Election Commission make its own rule? Supreme Court said, look at this term, this phrase, superintendence, direction, conduct, control. All these powers are plenary in character. Plenary in character, that means unrestricted by executive. Sir, what does that mean? It means superintendence, conduct, control of elections is vested with Election Commission of India. Whenever Election Commission of India does anything in these matters, in election matters, nobody, not even the executive, can restrict the powers of the Election Commission of India. And these powers are like reservoir of powers. Reservoir of powers in the sense, if there is a law passed by the parliament regarding the conduct of elections, Election Commission of India should follow that law, abide by that law, and make rules according to that law. But if the law is silent in a given situation, if the law is insufficient in a given situation, what you can do, Election Commission of India, you can supplement the law passed by the parliament. If this law is silent or insufficient in a given situation. So this is very confusing. Tell me clearly what it is. Election Commission of India is a constitutional body under Article 324. Clear? Yes, sir. Constitution says superintendence, direction, conduct and control of all the elections is vested in the body known as Election Commission of India. Right, sir. But what is superintendence, direction, conduct and control? For that matter went to the court. Why? Because election conduct rules were made by the Election Commission of India. Symbols order was issued by the Election Commission of India. Matter went to the court. Sadiq Ali, Kanaya Lal Umar. My lord, if the job of the parliament is to make law regarding the conduct of elections, how can Election Commission of India pass these orders? And these orders are like laws passed by Election Commission. But lawmaking is the job of the legislature. How can Election Commission of India pass these rules as if they are laws? And should Election Commission of India be bound by the law passed by the parliament? Or can it do anything which is not mentioned in the law? Can it do anything which is absent in the law? Can it do this? The Supreme Court said, listen to me. Superintendence, direction, conduct, control of all elections is vested in the body known as Election Commission of India, and these powers are plenary in character. Plenary in character, just like we have Article 142, where we can give any order so as to give complete justice. Right, sir? In the same manner, Election Commission of India can do anything to organize elections, and these powers are plenary in character, unrestricted by the executive. Sir, and what else? And all these give reservoir of powers to Election Commission. Reservoir, it's a place where water is stored, for example. When the water in your tap is insufficient, you take the water from the reservoir. Clear? If the law has been passed by the parliament regarding elections, election commission, you have to abide by that law. But if the law is insufficient in a given situation, if it is silent in a given situation, you can use your own thinking, you can pass your own rules. What Election Commission of India has done, Representation of the People Act talks about conduct of elections. But it was silent on whether symbols should be given to political parties or not, whether Election Commission of India can withdraw these symbols from political parties or not, whether for the conduct of elections, how do we appoint returning officers, how do we elect, how do we appoint some officers who can supervise elections. For that, the law was silent. That is why Election Commission of India used its reservoir and implemented these rules and orders. These orders, these rules are constitutional because under Article 324, superintendence, direction, conduct, control is vested with the Election Commission of India. Sir, it is still not clear. I'll give you one more example. Under Representation of the People Act 1951, we have section 14 and 15. What is section 14? What is section 15? It talks about election notification. What is election notification? First, the dates are announced. Election dates are announced by the Election Commission of India. You might have heard that there is a well-attended press conference. Chief Election Commissioner and the election commissioners, they address the press and they say, in Meghalaya, elections will take place on this date. In Nagaland on this date. In Tripura on this date. This is how the elections will be organized. And this is when the results will be declared. So dates are announced by Election Commission of India. Once the dates are announced, then a formal election notification is issued. By whom? By the president if it's a Lok Sabha election. By the governor if it's a state assembly election. That means formal notification that now elections will be conducted to this legislative assembly. This is the date of voting. This is the date of result. This is the date when you have to file your nomination papers. Formally, the notification is issued by the governor if it's a legislative assembly election, by the president if it's a Lok Sabha election. Clear? Gujarat, 2002. Riots took place. Prior to riots, there was a massive earthquake in Bhuj, in Kutch area of Gujarat. And ultimately, the then chief minister had to resign. He was forced to resign because he could not do something good during the earthquake. And then Mr. Modi was appointed as the chief minister. When Mr. Modi was appointed as the chief minister, then after some time, there was an unfortunate attack on the train in Godhra. The train consisted of some car sevaks who were coming back from Ayodhya, and then the passengers, they were burnt alive. Unfortunate event. It was an attack, and ultimately the passengers, those who were the Hindus, they were killed and burnt alive in that train. Then in response to that, there were riots between Hindus and Muslims in Gujarat, and ultimately the riots continued for a long time, which also led to the displacement of the people. So people, to save themselves, to save their life, they started migrating to other areas. Clear? So this was the environment. And then what Mr. Modi did, as the chief minister, he advised the governor, please dissolve the legislative assembly. Dissolve the legislative assembly. There was still some time left for the legislative assembly, but he advised the governor, dissolve legislative assembly, let's have fresh elections. So that in this fresh election, I can come back to power with a thumping majority. But when the legislative assembly was dissolved, Election Commission of India is not organizing elections, is not announcing the dates, is not holding the election. And the chief election commissioner at that time was J.M. Lingdo. Everybody is frustrated. Why Election Commission of India is not organizing the elections? And then it reached to a point where we realized and we thought and we asked, Can Election Commission of India refuse to conduct an election? Is that the power available with Election Commission of India? Is that the meaning of superintendence, direction, conduct, control? Some legal experts said, don't worry. If Election Commission of India is not announcing the dates, you can ask the governor, issue the election notification. Under section 15 of the Representation of the People Act, you issue the election notification. When the election notification is issued by the governor, then it is binding on the Election Commission of India to organize the elections based on that election notification. Do that. Mr. Modi, he was traveling different parts of the states. He said, Mitro, there is one person who is responsible for not organizing elections. That one person is depriving you of your legitimate government. And that person is James Michael Lyngdoh. Chief Election Commissioner is not organizing this rally. At that time, opposition political parties accused Mr. Modi of deliberately using the religion of Mr. Lyngdoh as the basis for discrimination. If you look at James Lyngdoh, you would not make out whether he's Christian or a Muslim or a Hindu or whatever. But when you say James Michael Lyngdoh, you're basically raising your religion as a matter. So today, when people criticize Election Commission of India, the government says, how dare you criticize Election Commission? It's an independent constitutional body. But the same Election Commission was criticized previously. At that time, Congress said, why are you criticizing Election Commission of India? But be that as it may, elections were not held. Matter went to the court using presidential reference. What is this presidential reference? Under Article 143 of the Constitution, Supreme Court is the advisor of the President of India. Supreme Court can refer any matter, President can refer any matter to the Supreme Court asking the advice of the Supreme Court on that matter. The President APJ Abdul Kalam, on the advice of the government, referred this matter to the Supreme Court. Dear Supreme Court, please advise what are the powers of the Supreme Court? What are the powers of the Election Commission of India? Supreme Court said superintendence, direction, conduct, control, all these are the powers of the Election Commission of India. And these powers are plenary in character, unrestricted by the executive. When to organize elections, when to hold elections, that is the domain of the Election Commission of India. Election Commission of India, come here. Why are you not organizing elections? Election Commission of India said we have the power and we have the responsibility to hold free and fair elections. In Gujarat right now, there's a turmoil. People have migrated from their areas to another areas. They may not have voting documents. They may not have voter cards. They may not have any documents to prove that they are the registered voters. In that situation, they cannot vote in these elections. When a significant population of Gujarat cannot vote in these elections because they have migrated, then this election would not be free and fair. That's why we are not organizing elections. Let the situation stabilize. We will organize elections. The Supreme Court said that is your power. But please, whenever there is dissolution of Legislative Assembly, whenever Legislative Assembly is dissolved prematurely, please, within 6 months, organize elections. And you can delay even beyond 6 months only if there is an act of God. If the term of the Legislative Assembly is 5 years, even before completing the 5-year term, Election Commission organizes the election. Because you know that the term would be over in this month, so we will plan accordingly, and by this date, election should be over, so that when the term is over, the new government, the new Legislative Assembly can start functioning. And that's what has happened in Meghalaya, in Tripura. Their term is not over. Their term will be continuing. But elections is already over. Results will be declared today. And once the results are declared, then the new Legislative Assembly will start its tenure. So even before a term is over, elections are organized. But when there is premature dissolution, when the term is still left for a Legislative Assembly, but the Chief Minister is advising, dissolve Legislative Assembly. In that situation, Election Commission, please take the earliest opportunity to organize elections and hold elections within 6 months. But Election Commission said we can still delay beyond 6 months if there is an act of God. If there is a tsunami, if there is an earthquake, we cannot hold elections. You can't tell us that you have to organize elections within 6 months. The Supreme Court said, okay, within 6 months, but if there is an act of God, you can delay it beyond 6 months as well. Then the Attorney General said, can the president or can the governor issue an election notification even without the announcement of dates by Election Commission of India? The Supreme Court said no. The governor has to issue the election notification and can issue election notification only on the recommendations of the Election Commission of India. Without the recommendation of Election Commission, without the dates announced by Election Commission, the governor cannot issue the election notification. That is the power of Election Commission of India. But court further said, Election Commission of India can supplement a law, but cannot supplant a law. What is the difference between supplementing and supplanting? The year was 1982. There was an election in Kerala in one constituency, Paravarur, or some call it Parur constituency. Parur constituency in Kerala. Elections were held, and for the first time, an electronic voting machine was used. The candidate who was defeated in this election approached the Supreme Court. My lord, please declare that this election is null and void. The court asked why? Sir, because Election Commission of India has used electronic voting machine, which is violative of Representation of the People Act 1951, which clearly says that election should take place through ballot papers. Election Commission was asked, what are you doing? Election Commission said, superintendence, direction, conduct, control of all elections is vested with us. The Supreme Court said, enough of enough. You can supplement a law if the law is silent in a given situation, if the law is insufficient in a given situation, but you can't supplant. Supplant in the sense, if the law explicitly tells you that election should be conducted through ballot papers, you cannot supplant and replace ballot paper with electronic voting machine. This election is null and void. You can only supplement, you cannot supplant. So then what is supplement? If the law says use ballot papers to conduct elections, now on this ballot paper, how do you mark your preference? That Election Commission, you decide. How should be the names arranged in this ballot paper? That you decide. Whether the names of the political parties, which are national political parties, will come first, or whether the names of the independent candidates contesting the election will come first, that you decide. So you can supplement the law passed by the parliament, but you cannot supplant. So this election to Paravarur constituency in 1982 in Kerala, which was conducted using an electronic voting machine, is null and void. Because Representation of the People Act, the law passed by the parliament, explicitly talks about conducting elections through ballot papers. It was only later in 1980s, in the late 1980s, in 1989, that Representation of the People Act 1951 was amended to provide for elections through electronic voting machines. And that is how, since then, EVMs have been used. That is Article 324 of the Constitution. Any questions? Why didn't the elections held in J&K according to the Constitution? Constitution does not say within 6 months. It's the Supreme Court which has said within 6 months. And there is a justification in J&K because first there had to be delimitation. Now delimitation is over. Now this is the job of the Election Commission. Now Election Commission will have to decide when to organize elections. Election Commission looks at the weather conditions, the climatic conditions as well. Since it is winter time, maybe now is not the right time to organize elections because then people's participation will be affected. And in the summer months, it is almost certain that elections will be held. We will leave it here today. We've discussed some of the constitutional provisions regarding elections. We discussed Article 324. But tomorrow, when we meet, we will discuss what is the composition of this Election Commission of India. Election Commission of India consists of Chief Election Commissioner and some election commissioners. How are they appointed? How are they removed? How does the Constitution ensure independence of the Election Commission of India? What are the reforms required in the composition of Election Commission of India or in the appointment of the Election Commission of India members and chairperson? Then we will look at the entire election process, which starts with the dates announced by Election Commission of India. As soon as the dates are announced, Model Code of Conduct comes into the picture. Then Model Code of Conduct remains in force till the declaration of results. So today elections will be declared, results will be declared, Model Code of Conduct would disappear in Nagaland, in Tripura, in Meghalaya. Then what is electronic voting machine? Is it good? Is it bad? Can it be hacked? Can it not be hacked? What are the reforms required in elections? What is the Representation of the People Act 1950, 1951? That we will discuss tomorrow. Tomorrow we will also take up previous year's question papers, and the remaining portion of elections we will cover on Monday, which is our last class on Indian polity. And there on Monday, I will also tell you which of the chapters in M. Lakshmikant should you read and which chapters you can skip. Is that clear? On what ground can we challenge the election related matters under Article 325 as bar? Election related matters. Now, what is that election related matter? Is it that you want to challenge the election of one candidate in the elections, saying, I'm not the winner, you are the winner? You can go to the High Court. After election, any dispute you can file in the High Courts. Mahesh, what's your doubt related to delimitation? What is election code of conduct, known as Model Code of Conduct, which we will discuss tomorrow? Sir, can you explain why elections are not held in Jammu and Kashmir? That's for the Election Commission to answer. I would not know. I can only speculate that first there had to be delimitation. Now that delimitation is complete, now Election Commission has to find a favorable time slot in which the election should be scheduled to ensure maximum participation of the people, which can happen in the summer, cannot happen in the harsh winter season. So that's why we will see that 2023 there will be elections in J&K. Sir, in Kashmir 2014 there were 87 seats. After delimitation it is increased to 90, but as per norms 2026 no delimitation can happen. How it happened in J&K? We discussed that, my dear. I think you joined late or you were sleeping when we discussed that. The number of seats for Jammu and Kashmir as a whole was 87, which included some seats for Ladakh. But then Ladakh is no longer part of J&K. Now the number of seats for J&K were 83. There are some seats which are reserved for Pakistan occupied Kashmir, but forget about it. If 83 is the number of seats for Jammu and Kashmir Legislative Assembly, then this 83 became 90. That means 7 seats were increased. Why? Because delimitation was carried out in J&K. Why it was carried out in J&K? Because Jammu and Kashmir Reorganization Act called for this. Why can Jammu and Kashmir be singled out when it cannot happen in any other state? Because J&K, according to the Supreme Court, is not a state, it's a union territory. And for union territories, you can increase the number of seats. Right to vote is a legal or constitutional right. It's a constitutional right under Article 326. Bye, Kanika. Thank you, Mahesh. Sir, as per previous year's question, is it legal or statutory right? Supreme Court said in Jan Chokidar case that right to vote is a statutory right. It's provided by the Representation of the People Act. But according to the official answer key released by the UPSC, right to vote is a constitutional right under Article 326. Anuj, what's your question? Is it necessary to go to High Court, not Supreme Court, in any election matter? If it's a matter related to Legislative Assembly, you have to go to the High Court. If it's a matter related to President and Vice President's election, you can only go to the Supreme Court. Sir, can we challenge delay in election in any court? Now, let's say you want to challenge the delay in the conduct of elections in Jammu and Kashmir. Even this case will be delayed in the Supreme Court. Then what's the point? Okay, that's about it. See you again tomorrow, 6 o'clock in the morning. Till then, have a great time. Bye bye. Stay safe.